Lordship, we filed yesterday CRPIO, my lord. Can it be possible for tomorrow?
May I please, Your Lordship? Lordship, I beg to mention for withdrawal, Lordship.
Monday?
Monday.
My lord. My lord, on 2nd of May, certain CRPs were filed, which were filed by Power Grid were listed. My lord, with regard to the Hilakanji matter. My lord, there were 6 CRPs which were listed.
Huh?
There were 6 CRPs which were listed. And my lord has fixed them on the 16th. That is tomorrow. And my lord was also of the opinion that the other pending matters, connected matters of the same kind, they may also be listed along. My lord, however, the order, my lord, only 2 matters were reflected. However, there were, my lord, 5 pending. We had sent an email on the same day. So, my lord, the other 3 matters which have been listed out, they may also be listed tomorrow, my lord. So there is
Give
no
the mention memo, they will be listed.
my lord. Also, my lord, we during the time when the 6 matters were listed, my lord, in that batch we had filed a total of 8. However, 6 were listed and 2 were in defect. And since, my lord, the defects have been cured. So, my lord, I humbly pray those 2 may also be listed tomorrow so that the matter can be decided upon.
Give your mention memos.
My lord. Highly obliged.
May I please, Your Lordship? Your Lordship, item number 13 and 14 in the hearing list. The matter has already been settled, Your Lordship. Sir, long back. It become infectious now. And for the petition.
Item number 13 and 14. It has been submitted by Mr. You.
A.N. Sharma, my lord. A.N. Sharma, my lord.
You are not there.
On behalf of Mr. S. Chamaria, my lord. Not on record.
Where's Mr. Samaria?
He's in the trial court, my lord.
Ask him to come. Mr. Jha, come together 2 o'clock.
Right.
Okay, because without his presence, it would not be proper.
May I please, Your Lordship? I'd like to mention item number 7. Lordship may kindly allow me to take first steps in respect of respondent number 5.
Huh?
Lordship may kindly allow me to take first steps in respect of respondent number 5.
See when the matter reaches.
Lordship. Obliged.
May I please, Lordship? I beg to mention of an I for listing, Lordship, in MSc appeal, Lordship.
9th of June. 9th of June.
Obliged.
Lordship, I'd like to mention item number 6. May the matter be adjourned for the day as my senior was out of the station and couldn't go through the file. And as well as like he couldn't prepare the case.
Review?
Yeah. Yes, Your Lordship.
What happened?
My senior was out of the station and so he couldn't go through the file and couldn't prepare as well.
Hello?
May the matter be adjourned for the day.
The review against my order?
Yes, Your Lordship.
My order?
Yeah.
The request being made on behalf of the petitioner, seeking an adjournment. To list the matter after 4 weeks.
Top of the list, item 1.
Mr. Doctor, we are in a matter pertaining to an appellate jurisdiction against an injunction order.
Correct.
The fact that both of you are fighting so much shows that there is a prima facie case. Balance of convenience, you are not in a position to sell. And he also has a right to claim. That is a matter of suit. So obviously, if you sell it, there will be a balance of convenience, there will be multiplicity of proceedings. The third is the irreparable loss, harm and injury. If you sell it, then there is again another problem which he may have to face. He may get a decree tomorrow in respect to the suit property, which will affect third-party rights, one. Secondly, there will be a lot of other problems which may arise. So, unless you say that there is no prima facie case, which the learned trial court in its discretion held that there is a prima facie case, how can this court interfere within the limited jurisdiction?
My only point, my lord, I've already argued also, that
Your point I've understood.
Yes.
Your point are twofold. First, it is a contingent contract. So unless there is a partition being done, there cannot be a sale. So as such, the sale cannot happen.
This number
Then-
one, my lord. Another point, which is the most important, that in favor of the plaintiff, no cause of action arose. Well, as per the agreement, the cause of action for the suit only being arose after, if the vendor failed to execute the sale deal after the 60% share is with partition. So therefore, the maintainability that touches upon the prima facie case. Lordship, my lord's judgment also says so, one of the recent judgments. So the contention is that unless there is cause of action, because the cause of action as per clause 6 would arise if I am failed to execute the sale deed after partition. And also the agreement is explicitly clear that the agreement would be concluded provided the separation of the shares. And also there is a clause.
But isn't there also an agreement that you will make an attempt to make the partition?
That I failed. But for my failure, as per the terms of the agreement, the vendee is agreed to take back his money as per clause 5. That's my point, my lord. So there no cause of action arose for filing of the suit. So it touches upon the jurisdiction, my lord. Lordship, kindly have a relook at clause 5.
No, clause 1.
Clause 1, there's a clear cut.
The vendors have agreed
Yes.
to get it separated
The
and
purchaser,
then convey the same to the vendee.
Lordship, the word is, the purchaser has agreed to purchase the property provided. Lordship, kindly have a look at the
If the
agreement.
separation of the vendors, 60%, the vendor fails to execute the sale deed on obtaining the NOC as agreed upon, the vendee shall have a liberty to get the sale deed executed and registered. If it is further agreed that if after the separation of the vendors 60%, the vendor fails to execute the
Yes.
registered sale deed on obtaining the NOC as agreed upon, the vendee shall have the liberty to get the sale deed executed and registered and recovered possession of the contracted property by deposit of the balance amount in the court. So his right will only arise after the separation.
Lordship, kindly have for a minute, Lordship, kindly have a look at clause 1 again. Clause 1. Second line. He is ready, willing, and agreed to purchase vending. The same provided. There is a clause, provided the vendor share is separate.
Where?
Clause number 1.
That the vendee is satisfied, the vendor are having 60% and he is
Correct.
ready and willing and agreed to purchase the same,
Provided.
provided the vendor's share is separated
So
from
just for a moment, I will just pause my thought. So he has agreed when provided share is separate. Admittedly, share is not separated as yet. So therefore, no cause of action, my lord. Again, my lord, kindly comes to clause 2, last 3 lines. Clause 2, my lord. the vendee is also agreed to purchase the same at the above price, provided the contracted share is separated. So again, reiterated that condition, provided. Now comes to, again, it's very clear in clause 5, clause 5, page 23. It is also agreed by between the parties that in case the vendor is not able to get the partition, as on the date this it has happened, my lord.
The
Within
agreement
that
shall
time-
be extended by them till another 2 months.
Another, therefore, by
Agreement
by
shall be-
19 March, this important, my lord. However, in case inordinate delay or non-extension of the period agreement, it was not extended by the first party as aforesaid, the second party shall have option to get back his advance money paid to the first party.
Now let
But-
us see how does he deal with this in his plaint.
By coming out from the contract, my lord.
Now understood, how does he deal with his plaint?
Now, this part, in except para 5, he has not, the plaint is silent. What prevented him from coming out from the contract?
Now this land,
my lord.
which is Schedule A.
Yes.
How much is the land? 15 kathas.
Schedule C,
What is the
Lot
land
C, my
agreed
lord.
to be sold?
Lot C is total land is 15.2 kathas.
15 kathas, 6 chataks.
Yes,
That's the land.
that's the land.
Now this land is in whose name?
In the name of all the principal defendants and the pro forma defendants. Mutated jointly. I will come to that part, my lord, with the permission of the Honorable Court, if my lord has permitted. Clause 6, my lord, kindly have a look of the agreement. Page 24. When the cause of action arose.
Or you mean to say after the date of the agreement,
Yes.
there has been no separation?
No separation, admittedly, my lord. Admittedly. And, my lord, both the vendors and the vendee, having well aware of the terms of the compromise, and having been well conscious of this fact, that the terms of the compromise in respect of this land, it is joint, undivided. The only clause is that we have to sell, dispose, or develop the land, and the sale consideration, receivable sale consideration will be distributed as per the share mentioned there. So therefore, the question is, my lord, whether I am competent to enter into the agreement, both the vendors and vendee. And the plaintiff has filed, along with the plaintiff, this compromise part of this schedule 4, the part of the plaintiff.
And what do you say about section 22 of the
I am
specific?
coming to that. Now, Lordship, just to point it out that The compromise is schedule 4, that is the Shillong Patti land. It is 15 kata, 6 chata. Now it's divided between the 3 plots, lot A, lot B, lot C. Now lot A allotted to a single individuals, 2100 square feet. Lot B also allotted to a single individual, 2100 square feet. And lot C, which is involved in this whole proceeding, lot C is 10.2 katas. Now, lot C starts with allotted jointly. Allotted jointly. Only division is how they receive their proportionate sale consideration amount. Or if developed, the sale, the constructed sale proceed of the constructed area. And it has to be distributed according to this share. It is very clear. And it is also provided that there would be no further partition. You may sell, dispose, or develop this entire plot. Because there is a reason perhaps of the parties, the front side is 48 feet. So it is parted between 20, 30, 40%, then the frontage, this is a commercial area, very thickly populated. It's a very well commercially viable area. Now this 48 feet, if I'm divided 20%, 30%, 10%, then the frontage will be less for the individual person. Therefore, they jointly decided that either we jointly develop it by a construction or we jointly sell it. And therefore, they said that it is to be clear that said lot shall not be parted or partitioned further. So therefore, my lord, that our client has entered, but the question is, if it is legally not permissible under this terms and compromise, whether I'm legally entitled to enter into an agreement with this person, and who is also aware with this fact of the terms of the compromise.
Let us see again the compromise. Page
184, my lord. It starts from page 181, schedule 4. Shillong Patti Silchar.
Let us see the original of page 184.
Yes, my lord. Is 320. My lord. T20. T2B.
So here there is a mistake at page 184.
184.
If you see it, sell or dispose or develop.
Yes.
Here it is written as off.
1. Dot B. Dot C. Agreed acceptance of the joint.
Page 325.
Yes, yes.
Are
320.
bound to sell or dispose or develop the said allotment.
Yes, madam. So typing. The parties are bound to sell or develop the sale. So all options are there. Dispose or sell altogether same. And the important part is, my lord, it is said that the receivable consideration, area as consideration shall be distributed among the parties according to the proportionate share mentioned herein. So it will be distributed according to their share.
So you mean to say that you entering into the agreement was wrong?
Yes. Therefore, if their law permits, I'm liable to be punished, my lord, because I am not legally competent to enter. Because it goes against the terms of the compromise. And both the parties, the vendor and vendee, both are aware of these facts.
But they were not party to this agreement.
Settlement, we were not party.
Subsequently, what happened, my lord? They are also the co-owners. So they, for the second, as I'm also inquired, the second compromise agreement also, the decree was passed, where there another shares not related to the Schedule 4, there was also allotted with another shares.
That is different.
That is a different.
That's a
So we
different
have
thing. But you mean to say that unless this decree is reversed or interfered with, the question of going for a partition does not arise.
to whom this land to be partitioned? With the pro forma defense, my lord. And pro forma defense correctly says, I must say, in the written statement, that we are not ready to partition this. We are ready to develop it jointly. And they say that we already offered to you for joint development of the, or give it to us. But you, behind our back, you entered into an agreement. So, in fact, they refused that the partition of that property of 60% and 40%, that is, it is impracticable and it is not possible to implement. Because it's covered with these terms and conditions. No court can get it parted. How can it overlook these terms of the compromise?
It is a decree.
This is a decree, my lord, compromise decree. Though he is not a party to that, but it is, we both principal defendant and the proper man are bound by this decree. So therefore, in the agreement, it has been provided that if I fail to partake it, 60% share as per clause 6,
Contract.
then he will take back his money.
Contract.
And if I'm after partition, if I fail to execute, then he has a right to. Before that, he has filed this suit without any cause of action arrangement. And therefore, he is the only remedy of section 20, my lord. Substituted performance of the company. As after the amendment of this specific relief act. And that clause is there in the agreement itself. Of section 20, touches upon the section 20, my lord. That you have a right to go for a substituted performance of the company, to take back his money. And he has also agreed. Now you file a suit and saying that for a specific purpose of the company. So therefore, my respectful submission, my lord, that unless there is a cause of action arose, how could a prima facie case would be established?
65, 60.
And when the agreement was for partition, after partition,
Yes. So section 20 will not come.
22.
22, sorry. 22 will not come because the agreement itself says it is a clear contract, my lord, of the sale and purchase. Because section 22 will comes only after the specific performance of the contract. It is a consequential sanction.
So any contract, if the specific performance is granted, even with 22, that would go against the preliminary decree.
My submission, my lord, that this is a conditional agreement. So it is not in conclusion. So therefore, that apparently this contract is not enforceable under law. If it is enforceable under law, then there would a question of section 22, my lord. Subsequently, that partition, possession, etc., etc. All the rights the vendee has. Now, the partition, even if he step in my shoes, then also the terms of the compromise applies. This is in the terms of the compromise decree, cannot separate. The only condition in the terms of the compromise, my lord, that just to distribute the receivable amounts or the receivable constructed areas as per the shares divided in the terms of the compromise. And here,
No, that, Mr. Dutta, that I have understood, but the only
yes,
thing is,
lordship is already there.
22 would not come into play. Would 22 come into play only on the basis of an agreement for sale?
Yes.
I'm asking you.
22, my lord, is a vendee's right.
22 will come in subject to 44 of the Transfer of Property Act.
Correct, man.
Now,
Now,
if there
here
is a
I am not the co-owner, my lord. Here the entire compromise decree says that some plots jointly allotted to somebody, some plots individually allotted.
No, we are only concerned with Lot C. Lot C, you are a co-owner. There's no quarrel with that. You are a co-owner.
Yes.
But while giving the Lot C, it says that there cannot be any further partition. Either you sell off, dispose of, or develop together.
Correct.
So that is a compromise decree which is being passed, which has now attained finality. That is. Now, if there is no partition permissible, even if he steps into the shoes under 44,
Then 22 would not come.
22 cannot come into the picture because his agreement is only for that 60% of the share. The mutation, the land still is in the name of the 4 persons.
All principal dependent and also the performance.
Is still in the name of the everybody. So there is not only a case of, yes, the shares have been ascertained by the trial court, by the compromise decree. But the revenue partition has not happened. Isn't it?
Yes, sir.
A perusal of the plaintiff seems that physical partition has not happened. That is the stand of the plaintiff. That everything else have been done, only physical partition had not happened. So it is only the physical partition is to be regarded. Physical partition means putting the fencing. This is what the plaint says in the plaint. So this, without that being done, it cannot. Now, can on the basis of an agreement for sale entered into with a co-owner, a person has a right to seek partition, because you see the scope of an agreement for sale is in terms with the proviso to section 54. It's a contract of sale by which he has only a no equity is there, unlike in England. Here only his right is to get a deed of sale executed in his favor. So can on the basis of an agreement for sale, a person can seek a partition in the suit in terms of 22.
My understanding is that the agreement to sell does not confer any title, admitted. So it has to be translated into a sale deed. If the sale deed is executed by a dictate of the court, then his right accrued. As per section.
So he can by 22.
Here the question is that once you himself agreed that the agreement is not enforceable unless it's partitioned. He has agreed.
Now, he has not agreed to it, is not enforceable. He says that I will purchase only
Subject to.
after the partition.
Yes, subject to, provided, subject to. And if not parted within a 4 months, I will take back money. So
And there is no mutual agreement of extension
no, admitted.
as per 5.
Because that time limit has been expired in the month of March, first week of March 2019.
But whatever may be, there are many judgments of the Supreme Court which says that time is not the essence.
That's the contract. I am not on that point. Time is not the essence of the matter.
So not
But
relying on
if my lord has taken into consideration the entire contract as a whole, if you
your
read,
basic case is on 27 then,
yes,
contingent
and 32, my lord.
32.
30. So therefore, my humble submission before my lord to be considered that my this cause of action would arose only after partition, and thereafter I am failed to execute the same. Then he has the right to file a suit for specific. There is a clear terms of the contract. We cannot go by this. Clause 6 is clear.
But if he says, then look here, there is also, I will purchase. There are not only only one thing. That you told him that, look here, I will get it partitioned. And then I will sell it to you. That is your agreement. You will get it partitioned is also a covenant in the agreement.
Yes. Correct.
Can he enforce that portion of that agreement and get us injunction? That till you don't get a partition, don't sell.
There is no evidence in the contract. The contract says,
No, clause 1.
the contract says this is concluded by clause 6. The entire contract is concluded by clause 6. Clause 6 says that only after partition if I'm failed to execute the same thing, not before that. Not before that. You cannot overlook the clause C. So if clause C is binding between the parties, his cause of action would arise after the partition. And if I fail to execute the same. That's a very simple matter.
But what about the last line of clause 1? The vendor has agreed to get the deed land partition.
That because the agreement entered, I agree that I will do it 60% within a time limit. That was also fixed. He also agreed that yes, subject to partition, I am agreed to partition. Now I am failed to do so for whatsoever reason. So therefore,
In fact, you can't. You can't go for partition in view of the decree.
therefore, this is a legal impediment against me. Without understanding this legal impediment, knowing fully well, without understanding the legal impediment, they entered into the agreement. But law will always prevail, my lord. By the
Unless
act of the parties will not nullify the law or the terms of the agreement, the compromise decree.
It's a decree, not an agreement.
Yes, it's a decree and it reaches to the finality. I cannot go beyond this decree. But this region or that region, my lord, I entered into
The
the
last line of clause 1 is not lawful.
The entire agreement is not of lawful.
No, we'll go into
So,
the last line. But if you see, your only threat, therefore, as per your argument, would be the plaintiff's right would only be as regards the last line to get a partition. But that partition can't happen unless there is that decree is modified.
Revisited, yes.
So therefore, that last line is not lawful.
No.
And unlawful agreement
Section
cannot
23
be,
of the contract act, my lord.
specific performance cannot happen.
Even if lordship is well aware that unless it's concluded, any contract, my lord, it must be, because there is a conditional contract subject to, provided I am purchased. So there is there in the agreement, in every step there is a bar.
No, that I understand.
Yes.
You see, there are two aspects of this agreement. One aspect is seeking specific performance for execution of a sale deed, which he cannot get unless you get it partitioned. So there 32 hits in.
Correct.
But he also has a right to compel you by way of a decree to go for partition.
Yes. Yes, correct, madam.
Which is the first paragraph, last line of first paragraph. So these are two aspects.
Yes.
Because what has happened otherwise is, you are going to otherwise sell it. You are making arrangement with third party and all. Where does its right go? So the only way, the first part may not happen. He may not get a cease for specific performance of the suit land.
Now, as per the terms of the compromise, my lord, I cannot sell 60% cannot be sold to the third parties also. I cannot.
There cannot be any partition.
Yes. I cannot sell 60% to the third party. It has to be a joint move by all the persons named in the lot C. Unless a joint move, I cannot, nobody therein individually can act.
So
Neither
if-
me or not they.
If they can get hold of the performer to their side, then
Then,
their injunction is maintainable.
Yes. Then also not, my lord.
Why?
Because
Then you can say it-
yes. Then
If he enters into an agreement with the performer
performer, then
and
I
says that,
also
and
agree.
then
They also
says
agree.
that
Yes.
I will pay him the double what I am paying it to you.
Yes.
And therefore he
then
can say,
joint
and they will
decision.
say that, okay,
Yes,
so then
joint
there will be a
decision.
joint sale, you will
Joint
be
decision.
compelled by this.
Yes, joint decision. Joint decision, as per terms of the compromise, they may approach to the performer. Man. They are all liberty, all are family members. Man.
Now, if they get double to what? You own 60.
Yes,
That 40% gets double of what 60 is.
yes, 2 plus 40 lakhs. Very good, very good also. Very good.
Yes, Mr. Mishra.
My lord, the entire argument is without any basis with respect to my lord.
Huh?
The entire argument is without any basis. He is harping on that he cannot he cannot partition. That's what is mentioned in Lot C at page 180. Now kindly come to page 142.
142.
And another thing, my lord, just I want to, if you lordship permit me. There was a preliminary decree. Your lordship will come to 140. Let me place it, then your lordship will see what argument has been made. Your lordship will come to paragraph 3 at page 140. Just few lines I will say, I'll not take your lordship through the whole thing. Just first 4 lines. In TS 10 of 1966 partition, a preliminary decree was passed on 3/12/1971, declaring shares of the parties. The shares of the parties are admitted. A partition commissioner was also appointed on 20th/12/1985. The commissioner of partition has filed his report on 21/8/2007. It may be mentioned here the writ commission was issued in the year 1985, and the commissioner's report was filed only in the year 2007, that is after 22 years of appointment. Then your lordship will come to 5. There is no fruitful development in the instant matter of partition. In the circumstances, the petitioner taken initiative for settlement of partition suit property and make a proposal of partition of all property schedule of their suit for all of the parties according to their respective share, and to negotiate the proposal with all the parties for finalization of the partition amicably. After a span of 48 years of filing the instant partition suit, the parties and all applicants have realized that the scheduled suit cannot be partitioned in metes and bounds without mutual intervention of the parties by means of amicable settlement. The partition is not at all possible. Then the last one in this paragraph 6.
Yes.
6 is the instant settlement is being formulated and thereby accepted by the parties as per their share declared and allocated, the lordship will see, in the preliminary decree. There was allocation of shares. Now your lordship will come to 9 at page 142. All parties of the instant settlement hereby agreed that in terms of the settlement, each of the parties will shift to their individual establishment, whether family, household, business, to their specific allotted area by vacating their existing occupied area, if that or those are not allotted to him or them, and shall also liable to hand over peaceful khas possession of that or those areas to particular specific allottees for particular lot schedule within 180 days from the date of finalization of this settlement by the Honorable High Court. So they were to go to their respective shares within 180 days from the date of the decree. This decree, which was on 2nd, my lord, which was passed on 2/2/2015, this decree. 180 days from the finalization of the settlement by Honorable Court with a valid notice for possession or mutual themselves in regard to their physical possession. Now, your lordship, this is important, and this has to be relative. This is relatable to Lot C at page 184. Until that period of actual possession, the parties have agreed to obtain joint allotment. So the joint allotment, which your lordship has seen at page 183, is until they get their they occupy their allotted share. And I will show from their pleading and agreement that they are in khas position. I'll show you. Have agreed to obtain joint allotment of their individual combined share in food premises, either by themselves or through their agents. 10 says we are not a party to this settlement. Now your lordship will come to just one paragraph, paragraph 12 at page 143. 143, madam. All the parties hereunto acknowledge and accept their respective entitlement for enjoyment for, there's a lot of mistake. Even in the original I saw that's also written science die. In group allotment till it gets separated mutually without any interference or intercession or control from any other party. And then this one, you know,
All the parties here to acknowledge and accept their respective entitlement for their enjoyment for since die, since die, in group allotment.
Yes,
Sinedai,
Synod, maybe.
Sinedai. In group allotment
Yes.
till it gets separated mutually without any intervention and interaction and control from any other parties or co-shares.
Yes.
So what does this mean?
This means, my lord, at page 84, 184, they were allotted jointly. But shares were given there. Lordship has seen, the vendors have 60%. And Lavanya Bhuya and Lakshmi Narayan Bhuya, they have 20 each, say 40%. So their share is given, they're given jointly till it is mutually decided and they separate.
But what do you say about lot C?
Huh.
Down below it is being mentioned that it is to be collectively sold and all.
Well, this is till they occupy their shares.
No, why then why they will mention the dispose and develop?
Well, that they have mentioned, but this cannot be read. Lot C cannot be read independent of 9 and 12.
No, 9 doesn't say that. That is
Yes,
why I'm saying.
Your lordship will
You
see.
see, here it says accept their respective entitlement for the parties.
Yes.
Here this is not single. It's a,
Well-
it's a plural.
Yes.
The parties here to acknowledge and accept their respective entitlement of their enjoyment
Yes,
for since they in group allotment
yes,
till it is separated mutually without any interference and interaction and control from any other part or co-sharer.
Right.
Now, when this clause is along with that, you have to read it where it says that there cannot be a partition.
well, it says until that period of the joint allotment.
No, but why does it in clause lot C? It is categorically mentioned there shall be no further
Madam,
partition.
Lot C, just let me explain. Lot C is joint allocation, which the party had agreed until, your lordship will see, until that period of actual partition. In 9 only, after 180 days by the honorable court with valid notice for possession or mutual themselves, physical possession, until that period of actual possession. Kindly
The
see.
family household business to the specific allotted area by vacating. But you have to read this until with the earlier portion of that line.
Yes, my lord, all separated.
Parties of the instant settlement hereby agreed that in terms with the terms of settlement, each of the parties will shift their
Yes.
individual establishment.
Each of the party, yes.
Each of the parties.
Yes.
Whether family household,
Yes.
business to
Business.
their specified location area
Yes.
by vacating the existing occupied area, if those are not allotted for them and shall also be liable to hand over peaceful cast possession of those areas to a particular specific allottee of the so-and-so within 180 days from the date of finalization of the settlement by the
Yes.
honorable court with
Yes.
valid notice of possession or mutual themselves in so-and-so.
Yes.
So therefore, this has to be only meant to in respect to, just for example, A is being given an X land. where A, but B is staying out there, the B has to go to that.
Specific allotted area, because, my lord,
And until then,
yes,
until the period of actual
Actual-
possession, the parties have agreed to obtain joint
Joint-
allotment of the individual,
Yes.
meaning that till then, because
Yes.
otherwise they will have to be, they would not have any right out there. So what happens, they will be agreed to obtain the joint of the individual's
Yes.
combined share in the suit premises, either by themselves or through their authorized representative.
now, according to my submission is, my lord,
Mm.
this lordship partition, because your lordship has seen in paragraph 3,
Mm.
that there was a preliminary decree which allocated the shares.
Mm.
Paragraph 3 clearly says.
Mm.
Then paragraph 5 says it could not be divided by metes and bounds
Mm.
unless the party agrees.
Mm.
Therefore, joint allotments were made. Wherever it was possible, they agreed, all right, till we go occupy actually, there will be joint possession, joint. So these are temporary things till they are in khas position. And it is an admitted position that they are in khas possession of 60% land.
How do you say so?
As admission is there, I'll place.
But your own statement is that in your claim that there is no further, there is no fencing or
there is-
yeah.
my lord,
That is your
the-
statement
yes,
in your
yes.
claim.
Well, I'm not, what I'm saying is physical demarcation is not there.
Then
I will show. My lord, how there, suppose, my lord, there is a big plot and 3 brothers are there. The temporary, all right, this is yours, this
kindly
is
come to
mine.
paragraph
and this
4
is
of your
his.
plaint,
Yes.
page 32,
Yes.
paragraph 4 of your.
Yes,
That according to the principal defendant
Yes.
offered to sell 60% of the share of the Iman on the southern side of the plot of land of the plaintiff, who is a close relative of the defendant.
my lord.
And the plaintiff also agreed to purchase the same, and
Also, yes.
accordingly, the price of the same was
Mm.
fixed at so and so.
Yes,
Although 60% share of the physical area was mutually
Mutually-
partitioned with
yes.
Laboina and so, but that was not physically separated by putting
Yes,
any
so the
fence
fencing
or
was not
wall,
there.
nor was induced
Yes,
in writing,
yes.
as there was a standing proposal to sell the land to Laboina and Lakshmi Bhuya. And as such, the entire plot remained physically unseparated between the principal defendant, so and the
My lord,
performer.
they are in the khas possession, only a line has to be drawn. This is, I said on the first day. And I will show from there, if your lordship permit me. Kindly come to the agreement. Their agreement, page 20. Kindly come to the agreement, my lord. Page 20.
Yeah.
My lord, let me place, my lord, the second recital first. At page 21. Whereas the proposed vendors initially offered to sell their land of to Lavanya Bhuya and Lakshmi Narayan Bhuya. It is there, my lord, agreement, and this is admitted. As they needed funds for their personal necessity, but they declined to purchase the same as they are lacking so much fund. Lavanya Bhuya and others. In mutual discussion, it was decided later that the vendors shall take 60% of the share from the southern side of the plot, and Lavanya Bhuya and Lakshmi Narayan Bhuya will take 40% share from the northern side of Schedule A plot. And accordingly, partition will be made between them. However, this is very important for me, Miller. However, the vendors and Lavanya Bhuya and Lakshmi Bhuya are in khas position of Schedule A. Their respective land, they are in khas position.
That means they are all in possession,
No.
joint possession.
My lord,
Yes.
my lord, when khas position is there, because he says, your lordship, when vendor means these 3 persons.
And the performer.
They are in khas position.
Yes.
So khas position is the land that is according to their share in the partition, and they are occupying that respective land.
Khas possession of the Schedule A land
Yes,
means the
sir.
entire land.
I'll further show, my lord. I'll further show. Your lordship will come to ground 1, page 16. I'll take your lordships through
Mr.
page
Mishra,
16.
what do you mean by khas?
Khas means a demarcated portion,
No.
a particular portion.
Khas is actually a Bengali word. It means about, it is actually a government property. The
Khas.
government. When it says it is actually, it is being used. Therefore, in the land and revenue regulation, you would not find the word khas, except in Rule 18.2, they have brought in khas possession aspect out there, although there is no word of khas anywhere. Concept
So
of
far-
khas is not there.
So far, we in the Hindi welfare concern, we know khas and am. Am is public, khas is mine.
Yeah, but in the plaint, you will see that a recovery of khas possession of the land and all.
Yeah, that I've seen, that's right. Now, your lordship will come to page 60.
Page?
Their own appeal
1/6.
before your lordship, 1/6 of the present my lord appeal, FAO. Page 16.
Yes.
For that, a co-joint reading of both the plaint and the written statement of the objection goes to show that the appellants are in actual physical possession of their land. And the land in question has not been partitioned as yet. So they are in actual possession. Now, this could be by not a ploy, because they don't want to sell. They're getting customers, the value has gone, it's in a prime space, place, they don't want to sell. So these things are coming. But the admission fact is that they are in physical possession of the land. And another thing, there is an admission that I'm in possession of the land, you cannot deprive me of the right to enjoy the land. It is in respect of, my lord, I'll just show your lordship. Page 17, my lord, ground J. This is because my lord, the last page of this appeal, your lordship will see the 122. 122, my lord. I'll place the impugn order first, the operative portion at page 122.
Mr. Mishra, show it to me on a basis of something which is there on affidavit.
My lord,
When I was practicing, one day I was moving a matter before Justice B.P. Kotoki. I was also referring on the ground. So he said, not on the grounds. Grounds are grounds of objection.
okay,
And that too on the certificate given by him.
I'll do that also. I'll do that also. I'm just taking your lordship through the sequence that you see. At one place, he can make a mistake, but not repeatedly. This is why I'm saying your lordship will take it. I'll take your lordship to 122.
Let us see their written
122.
statement of the defendant, the objection. Where's your written objection?
My lord,
Got it. Yeah, page 84.
my lord. That is. Your lordship will kindly come to this thing 122 if your lordship come, and then it will be relatable to the ground, and also the statement made in paragraph 14 of their written statement.
Yes.
My lord will kindly come to page 122, the last page of the FAO.
Yes.
Hence being the third part, third person, the operating part. Hence, being satisfied prima facie as to the existence of all three golden ingredients in favor of the petitioner, the plaintiff, for the sake of fair trial and preserve the suit property, the principal opposite party, defendants, their men, agents are hereby restrained from any way alienating the title or transferring the possession of the scheduled property, that is 60% of the principal's defendant, to any third party, or for changing the nature and feature of the same till disposal of the main case. Now, your lordship will see what objection they have taken in the ground, page 17, if your lordship will come. Page 17.
Page?
It's ground J, my lord, it starts at page 16. And then 17, the relevant portion, 7th line from the bottom, if my lord will kindly see.
Yes.
In the instant case, it is admitted position that appellants are in possession of the land in question, as they cannot be, as such, they cannot be restrained from enjoying their property. They are in possession of that 60% land. And there is a joint mutation order that was passed in 2016. Now that has to be separated. And no physical separation that way is required. I will again, my lord, show your lordship to take your lordships to their written statement. Their written statement, and which I will read with my lord paragraph.
So you want to therefore say,
Yes,
so there is no partition required.
my lord, the part, so far as the land is there concerned, they are in possession. All the vendors are in their possession. Separately, it's not joint possession. They are possessing their share. And Lavanya and others, they are possessing their share. Now, because there is a mutation, and that mutation, my lord, is of 10-1, if I remember, my lord, 10-1.
After this decree.
Yes. No, yes, 15, the decree was 15. The joint mutation was long before 10-11-2016. This is at page 373. So that has to be separated. 373.
So therefore, there is a requirement of a partition.
The partition, in a sense, I'll put it, my lord, this way. Well, let's suppose there is a land and we have mutually decided. It's an admitted position that there was a mutual decision regarding partition. And that is what the decree also says, preliminary compromise decree. Everybody is in their respective position. But the land stands jointly in the record of rights. So that has to be separated.
No, the lands stood in the joint the record of rights only in 2016 after the decree, on the basis of the decree.
Yes.
So not earlier.
No, not that.
So on the basis of the decree, it has now become a joint property amongst all these principal defendants and the performer defendants. So
That's right.
therefore, my question is a partition required or not?
Partition is required in so far as correcting the record of rights are concerned. This is my answer to that.
So there is no
Physically-
requirement of dividing.
They is already divided, they are.
No.
holding shares.
Somebody may say 60%. Just for example, let us
Yes,
take an example of a
yes.
suit.
Hmm.
In a suit which is in a land which is accessible to the land revenue, what is the requirement of a suit for partition is the court will only declare whose share is how much. When it goes for partition before the authority, on the basis of the share, who is in possession out there, the heir will pass an order under 54 stating, okay, this is the particular plot of land which is A. This is now been divided amongst these 3% by B, C, and D. B is of now dag number Iman, patta number Iman. C is of dag number Soyan, and yeah. So then the matter is complete.
Yeah.
So you don't need that.
That will be required because the.
There
thing
is the
there.
question is. So
Now-
without that, how can there be a suit for
No,
specific
there are
performance.
two questions here. One is whether the decree prevents, whether the compromise decree prevents any partition.
So therefore, the first line,
This is,
the last line of paragraph number 1
yes,
is the issue. Because if there, can you enforce the suit,
yes.
the enforce the contract insofar as asking him to go for partition?
Well,
The second will take, because of that, you may ask for an injunction. Because you also have a you have also claimed the right of partition. So therefore, can you ask for specific, because the specific performance is cannot only what he says to be only 6, no. It will include every covenant. It will include, just for example, one of the judgments of the Supreme Court says that when you say that he will execute the deed of sale after taking the permission, you can not only execute for a deed of sale, but you also can ask for specific performance for him to seek the permission also. So therefore, as regards the last line, you can very well do so, provided it is not affected by the decree.
Now, well, if your lordship will see this particular 184, and just please it, it is to be clear. Page 184. Reading from just below the percentage matter mentioned. The said party hereby agrees to accept the said lot C as jointly accordance with the mentioned here and shall dispose of, sell or develop the land. This is one. Receivable consideration area as consideration shall be distributed among parties according to the proportionate share mentioned therein. It is to be cleared that the said lot shall not be parted or partitioned. Further, the parties are bound to sell and dispose of the said allotment.
Or develop.
Develop
The
now,
same.
my lord, my submission would be that the partition is done, the allotment is done, because the partition they were not able to do the partition by meets and bounds. That paragraph 5 which I have placed of this compromise. That is how they agreed to accept joint allotment. And this joint allotment, again, if your lordship will read at page 142, my lord, at page 142. 143,
Yes,
paragraph 12. The said parties hereunto acknowledge and accept their respective entitlement for their enjoyment for sine die in group allotment till it get separated mutually without any interference. Now, my submission would be mutually they have agreed and it is reflected. If your lordship will kindly turn to take their WS filed in this present suit, Miller, at page 71. Page 71. Page 71, you know, that the statement made in paragraph 3 of the print insofar relates to defendant is not important. What is important is third paragraph on page 72. There's admission. It is admitted that it was mutually decided between the defendants and Lavanya Narayan Bhunya that the defendant shall take 60% of Schedule A land from southern side of the plot, while Lavanya and Lakshmi Narayan Bhunya will take 40% share from the northern side. However, written conveyance or written instrument are not entered. The fact remains that they are in possession of their land. So, if your lordship again take paragraph 12 of the compromise decree at page 143, 143, all the parties hereunto acknowledge and accept their respective entitlement for enjoyment in group allotment till it gets separated mutually.
But what do you say about the written statement filed by the performer defendant numbers 5, 6, and 8? Because
Yes.
this happened between you and him,
Yes,
where the 5, 6, and 8 has not agreed to anything, not mentioned anything.
But-
Now here you say at paragraph number 8 of the said written statement, they say that both of you have collided together.
no, that's what I'm saying. Now they have collided because the price of the land has gone up. They will give it to the builder and they will get lots of money. They want to get rid of this. That is how it is. Otherwise, why he did not challenge the suit, the agreement which was filed? So, my lord, it is, now kindly see this, let me just place one line. Till it gets separated mutually. Now, if your lordship will say that page 184.
Are you
lot
saying
C-
that clause 13 will
Yes.
override what is stated in lot C?
Yes,
How?
because it is temporarily, my lord, this compromise agreement, decree is based on the partition degree. I don't want to repeat it again. And the other, my lord, clauses which are mentioned in the compromise decree. So Lord C was, even paragraph 9 says at 140, until the actual position.
But lot C makes it very clear that the said party
that-
hereby agreed to accept the said lot C in jointly in accordance with the above mentioned share and shall dispose, sell, or develop the said lot.
My lord.
Receivable consideration or so and so. It is clear that the said lot shall not be parted or partitioned further.
So, my lord, what I'm saying, trying to say, my lord, that this cannot be read in isolation. This has to be read with other part. The other part of the compromise decree, which clearly says that until the period of actual possession, the parties have agreed to obtain joint allotment. This cannot be ignored, cannot be left out while.
No, that is in respect to those people who were in not possession of certain properties which has fell into the share of somebody else.
No,
There
that
they
is-
will
that is-
remain.
That was to be done within 180 days. That was to be done. Kindly see, that
In
was to
fact,
be done.
No, after the decree
Yes.
being passed,
Yes.
they got their names of jointly. Why didn't they get it under 60, 20, and
No, no,
40?
no, we don't do that. That they are the person to explain why they did not, because they themselves say that we agreed and we have taken possession. They say we are in possession of the land. They are saying that.
So where they have stated they are in complete possession of their only
Complete, they
60%.
have not said, but they are in possession of their land, they have said.
They are saying that they are in possession of that land. Where did it say? Let
My
us
lord,
see.
my lord,
Because
my lord-
that I could not see in their objection.
my lord, paragraph 14 as page 71, I have taken your lordship through.
Now that they say
Huh.
it was proposed to sell. Here it is
Yes.
saying that it is admitted and it was mutually agreed between the so and that the defendant shall take 60% share of the schedule from the southern side of the plot,
Yes.
while so and so share from the northern side of the.
Yes, my lord.
However written. So it was agreed.
Agreed. And now your lordship will see that parties are in possession
Of their,
of their land.
so there is no partition required. So therefore my question was whether partition is required.
My submission would be, as I understand, my lord, that they are already there. It has to be formalized and no physical separation as such is required.
Because Mr. Mishra, normally in a case,
Yes.
he can sell it. There's no quarrel. We don't require partition also. In view of section
Yes.
44, he can very well sell it. And more particularly when the decree says he has a right over 60%. Thereupon, you can very well ask for partition. There's no quarrel with that. But the decree is causing the problem to the effect
That's
in
right.
lot C.
My only submission
Otherwise,
regarding-
there is no requirement.
But
for
my
partition.
only submission regarding that is, decree is, that cannot be read in isolation, that has to be read with 9 and 12. It cannot be read, my lord.
Otherwise, there is no there is no
And
problem
my
at all.
lord, another submission that I'll make is,
Hmm.
that they can raise those points. They've taken the point of maintainability. They will argue there. Your lordship is saying only about the.
I'm not going to decide it to that effect. I'm
uh,
only seeing as to whether there is a prima facie case.
Yes.
If there's no prima facie case, other two goes, whether there is or not.
But your lordship will see. Your lordship will see so far as it will not be partitioned or it will not be parted. But they're going to part it. Once this injunction goes, they'll part it. I'll be left with no answer, no remedy. Because your lordship has to construe.
But if they
whether-
don't partition, then what happens?
My lord,
If they don't partition, then
my lord, if they don't partition, they have agreed to to do the partition. That they have not done. Now we have come to the court. Then the court will decide. The entire matter is there before the court. So it's not that.
no, if Lot C cannot be partitioned, then what happens?
My lord, I'm saying, I don't want to repeat, my lord, whatever I have already argued, but what I'm saying is, Part C is
Cannot be
a joint,
read in isolation without line.
and then, my lord, it's a joint allocation, joint allotment. Why joint allotment is being made is given in paragraph 9 and 12. That was the reason. So there is no bar as such. And your lordship is aware with section 10. Of course, it is section 10 of the Transfer of Property Act. If I have a property, alienation cannot be stopped. I'm not saying that the decree has stopped it, but I'm saying it just cannot be done. Condition restraining alienation. It will be illegal.
But for that, the decree has to be bad.
Which
For that, the decree has to be bad.
decree may be, my first submission would be that in view of section 10, the Honorable Calcutta High Court could not have been intended to pass this for all times.
That is too far for me to
No,
go.
No, what I'm saying is, no, my primary submission would be,
That day I was taking a matter where that is a very highly contested matter, where this court had passed an order. It was one of the the plaintiff, after getting any ex parte injunction, he died. Now, the suit was filed against his daughter, so only daughter. So the suit was normally, but the plaintiff had made a will. So the person who was the executor, he came up that I should be substituted. And the other side, the daughter said that nothing doing, the suit should abate. The trial court said dismiss both the applications and said that no, till the probate is not done, no substitution, suit stayed. Matter came up before this court in 2012. This court passed an order to that effect that the order is right. And there were two judgments of the Supreme Court of 3 judges, however, not on the point, but there were 2 judgments of the Supreme Court subsequently, which was absolutely on the point. The single judge out here or a coordinate bench held it that judgments of the Supreme Court are pari in curiam. And then nobody went to the Supreme Court. After 12 years, they have come before me, and it has happened that they are filing 151 for recalls. So I'm to pass that order. So similar thing, you may have to do it out there. Chalo, hearing complete, judgment reserved.
Only one reply, my lord, if not pardon me. In agreement, I have agreed that my part is southern, the Lavenders part is northern. But the problem is, my lord, that the Lavendo not a party to this agreement.
That is
Yes,
the
that's
question
the
I
point,
put to
my lord.
him.
That's the point.
No, that
Lavanya
is
is the pro forma
No,
respondent
Mr.
in the
Doctor,
play.
that is the question I put to him and showed him paragraph number 8 of the written statement filed by the performer defendant
Yes,
number 5.
that's the problem. Get to-
He may have to amend his suit if necessary because of the stand now taken by the performer defendant.
Yes.
Anyway, that
Oh,
is his.
lordship.
Supplementary item 17.
Yes, again you start.
Lordship, the pay fixation of stenographer grade 3 under the fifth CPC was in the pay scale of 3850 to 7350, Lordship.
Yeah.
Lord, under the fifth CPC, Lordship, the pay scale was from 3850 to 7350, Lordship. That Lordship will find at page 94, Lord.
Page 39, you were appointed
Lordship.
as grade 3 on
Yes, Lordship.
21/9/2016.
Yes, Lordship.
Okay.
Yes, Lord.
Now, when you were appointed in the scale of pay of 5,200 to 20,020
200.
plus GP 2,900 and other allowances.
Yes,
Isn't
Lord.
it?
Yes, Lordship.
Now, this is in pursuance to the advertisement.
Yes, Lordship.
The advertisement stated categorically that you will be appointed again in this scale of pay,
Yes, yes, Lord.
page 29. Now thereafter on, what has happened? You were given the corresponding scale of pay, which is there.
Lordship, that corresponding scale, Lordship will find at
Page 49.
yes, Lordship. That is under 7 CPC, Lordship.
Okay,
But
what is your
on the-
corresponding scale of pay?
Yes, Lord. Under 6 CPC, Lordship,
Huh?
under 6 CPC, that is under ROP 2010, Lordship, the fixation which they ought to have made is at page 114, Lordship. Lordship, this is fitment table 10 under ROP 2010. Lordship, herein, that,
Serial number 14.
no, serial number 1, Lordship.
Yes.
Serial number 1, the pre-revised scale that is under fifth CPC was 3850 to 7350, Lordship, in the upper side, left-hand side, Lordship. And the corresponding pay band is 5200 to 20200 plus herein, Lordship, this grade pay 2400, Lordship. It's being amended, Lordship, and that Lordship will see this, Lordship. I have got the 6 CPC and the fitment table also, Lordship. That was amended. Now, why I say that, Lordship, there is a subsequent notification of 2011 that Lordship will find at page 115, Lordship. Here in,
Read it.
in the, at page 116, the grade pay of 2400 was amended to 2900, Lordship.
Hmm.
Subsequently, Lordship, that was incorporated, but herein in this fitment table, it's not being reflected, Lordship. But the pay scale that is of 3850 initially, that is at serial number 1, was to be revised to 7170, Lordship. That is based
Where is that page again?
the 114, Lordship.
$3850.
Serial number 1, 3850 is the basic pre-revised pay scale, and in the right-hand column, Lordship will find that it was to be revised to 7170, Lordship.
Then
Lordship, now what they have done, in their affidavit, they have stated that some calculations they have made, Lordship, and stated that another office memorandum will apply, and as per that office memorandum, this 7170 won't be given to me, Lordship. But Lordship, what had happened, in that office memorandum, this pay scale, Lordship,
No, where are you getting 3850?
3850, that Lordship will get at page 97, Lordship. That is under fifth CPC. That is in their affidavit, Lordship. The recommendation made by,
3850.
yes, Lordship.
But this says, but your advertisement said 5200 to 2020.
Lordship, but the analogy has to be drawn from herein, Lordship, because they have reduced my scale in the under the ROP rules 2010 itself, Lordship. But that won't be, that reduction won't be applicable in my case, Lordship. That's what I'm trying to say, Lordship.
No, there was an advertisement given of 5200 to 20,020. That was the advertisement. Your appointment order also gives that.
Yes, Lordship.
Okay.
Lordship.
You took the appointment on the basis thereof.
Yes, Lordship.
Now you say that it should have been from 7170
Yes, Lordship.
onwards.
Yes.
So it is some other payment. What is that respective payment then?
It is that payment only, Lordship.
What payment? Payment cannot be only one. What is the payment of 7170?
Lordship, it's that 5,000 to, because it's being reflected in 5,200 to 20,200. That is the payment, Lordship.
Okay.
And it's
So therefore your scale should have been 7170
yes, Lordship.
pay scale.
Yes,
At the time of your appointment, taking into account 3850 was the pay scale.
yes, Lordship. Yes,
So 3850 corresponding is 7170.
yes, Lordship.
And therefore, although the pay scale was 5,200 to 20,200, but your pay should have been fixed at 7170.
Yes, Lordship.
That's your submission.
Yes, Lordship.
Okay. Now thereafter,
Now, thereafter, Lordship, this was revised under the ROP 2017, and Lordship will find that it at page 49, Lordship. This is documentation. Now, that 7170 plus that grade pay of 2,900 comes to 10610, serial number 10, Lordship.
so that means you are adding 7170 plus
Yes.
2,900.
Yes, Lordship.
Then it comes to,
Then it comes to 10610.
and the corresponding, therefore, the pay is to 27,900,
90, Lordship.
and in the payment of
That,
which PB pay is
14,000 to 49,000, Lordship, and grade pay of 7,400.
Huh?
That is the revised one, Lordship. The revised payment under the 7 CPC would be in the payment of 14,000 to 49,000, Lordship.
So you should get therefore 27,900,
Yes, Lordship.
990.
990, Lordship.
So therefore your salary was rightly fixed at 27,990.
At the time of my when this ROP rules were affected in my case.
When you are, because your appointment also dates back to that.
Lordship. But after the publication of these rules, Lordship, they affected it. But prior to the publication, my appointment was made, Lordship. Just prior to the publication, Lordship.
Your appointment was done.
Yes, Lordship.
Because their rules, although made in 2017, but were given effect from 1/1/2016.
Yes, yes,
So therefore, this has happened.
Lordship.
Now, what is their stand as per you?
Their stand in their affidavit, Lordship, is that I could not have got that amount of rupees. The fixation,
27,990.
yes, 7,990 Lordship. Yes, they,
Why?
in their affidavit Lordship, they have given some calculations Lordship. And those calculations are based upon an office memorandum Lordship. That Lordship will find at page 90. This office memorandum it starts at page 90 Lordship. But then at page 91 Lordship, the pay scales are being given Lordship. And herein Lordship, this pre-revised pay scale of 3850 to 7350 does not appear Lordship. At page 91, this pay scale does not appear. So my case, Lordship, does not come under this office memorandum, Lordship.
Let us read. What does it say?
This office memorandum is particularly with respect to those who
Following pay structure shall be applicable for a aforesaid category of employees. It shall consist of only 15 grades corresponding to 15 numbers of pre-revised direct entry pay scales. These pay structures shall apply at the time of entry in the service. Subsequently, the revised structure with 30 grades shall be system of enforceability. And what were you referring to? Some other, another person who was appointed to there?
that come Lordship. First, let me clarify one thing, Lordship. Here in Lordship, they say that under the ROP 2017, the grade 3 stenographer, the pay was reduced, Lordship, under ROP 2017. But in respect of their pay with regard to that ROP 2010, there is no statement with regard to the reduction of the pay scale in respect of grade 3 stenographer, Lordship. Now, while bringing in this office memorandum, Lordship, they have never stated anywhere, Lordship, that the pay was reduced after that implementation of ROP 2010, Lordship. Now, Lordship, apparently the ROP was published earlier, Lordship, prior to this office memorandum, Lordship. Can this office memorandum override the effect of these fitment tables under the ROP rules which were published in 2010, Lordship?
Now, this office memorandum of 2010 does not include 3850.
No, it doesn't.
So that is not there.
No.
So the
And they have no-
3850 corresponding is 7170.
Yes, Lordship.
And 7170 as per you, as per that one,
Fitment table 10.
it comes to 27,990,
Yes, Lordship.
isn't it?
Yes.
Now, your thing is that the office memorandum of 28 July 2010 could not have come into place, affected you,
Lordship.
taking into account that your scale of pay is not there in the pay structure, which is there from 1 to 15.
Lordship. Yes.
So then what else do you want to say?
Lordship, that one I wanted to clarify that even though under the ROP 2017, the pay of grade 3 stenographer was reduced, but the pay was not reduced when the ROP 2010 came in, Lordship. That I wanted to submit, Lordship. Because although I am protected, I showed it on the last occasion, Lordship, as per provision 5, I was protected under that ROP 2017. But that provision never came in ROP 2010 because there was no change, Lordship. As your lordship got it. At that point of time, the pay was not reduced, lordship. But now, when this ROP 2000 new 7 CPC came in, lordship, they had apparently reduced it, lordship, in respect of the other newly recruited ones. But the ones who were recruited earlier were given the earlier pay scale. That was higher.
So
lordship.
you come within the ambit of the note.
Yes, lordship, that they have itself clarified. Now, they did not hit me there, lordship. They hit me where they said that under the 6 CPC itself, lordship, I ought to have got a reduced pay, lordship. In terms of this office memorandum, lordship. So that per se is, as I have showed, that case.
So this office memorandum says what? 2010.
2010, that in respect of the newly recruited employees, these pay is to be given, lordship. Now my pay scale,
So here it says that pay structure for future recruits
lordship,
who entered in the service of the Assam government on or after the 4th of February 2010 shall be in these pay bands.
lordship,
Therefore, they say they shall be in these pay bands.
yes, lordship,
So they have 3130,
3130, it's there, lordship,
which is 6,600,
yes, lordship.
isn't it?
But that 3850 is not here, lordship.
So you mean to say that in the rules of stenographer,
Not of stenographer, under the ROP 2010 rules.
no, they have closed the stenographer thing now. Where is that? Yeah, what is this?
That is under safety commission, they have adopted it, lordship. At page, it starts at page 94, lordship.
So they have adopted this one,
Yes, lordship,
the Chetty Commission.
safety commission. They have adopted it. That was enhanced, lordship. That
No,
pay
this,
was enhanced.
no, this you have our recommendation. Views of the High Court in Assam, there are 3 grades of AI as in Assam. In the state of Assam, there are entry level that has been given the same pay grade of 53. However, the minimum of the pay scale is lower than the stenographer 3, but the maximum is 2 and 4. Grade 2, however, gives higher starting in 9.6. We have considered the importance of the efficient demand for judicial and we have emphasized that they should for these and other reasons stated in chapter 10. We make the following specific recommendations for the grade 3 stenographers for the 3 levels of post pay scale. So who has given this?
This, this was adopted under the anomaly committee for the lordship.
Huh? There was a recommendation. Did they accept this?
They accepted it, lordship, yes.
Huh?
Yes, lordship, it's their affidavit, they have taken that stand, lordship.
They have accepted that.
Yes, lordship.
Because
3850 to 7350 was accepted, lordship.
And it shall be.
Page 83, lordship, will find a table, 2 tables are there in the lordship. Page 83, lordship, will find 83.
So at page 81, the second paragraph, they say, in the office memorandum dated 28/7/2010, the GP of so-and-so
Lordship.
corresponding to year was not included,
Hmm,
as this scale was meant for promotional posts.
Lordship.
Now the petitioner was recruited in the pay scale of so-and-so on so-and-so. Her pay was erroneously fixed at so-and-so plus Iman is equals to 10,000 so-and-so. The amount of year was derived by multiplying the minimum of the pre-revised into 1.86.
Herein, Lordship, the second paragraph and the third paragraph is contradictory to each other because if grade pay of 2,900 was only for the promotional post, Lordship, how she could have been recruited in that grade pay, Lordship? In paragraph 3, they have clearly stated that she was recruited in that grade pay of 2,900. Now, my contention herein is, Lordship,
No, kindly see this. This is an important thing.
Lordship,
Why it is so? There are two aspects at page 90. First is those who were appointed post 2006 but before 2010. And the second is those who were appointed post 2010. Those who have been appointed post 2006 but before 2010, there will be a multiplication of the fitment factor of 1.86, which is not there for those recruited after 2010, and they fall within the pay structure, pay bands. And this pay band of 3850 was not there. You see, why they say, because this has to be promotional post. You would not come under 1 of Annexure A, page 90. You can't come under 1.
Lordship.
Because therefore, there cannot be a multiplication with 1.86. So those appointed, because this revised from 2010, I think from 4th of February 2010, it was the date of the notification on which the 6th pay came. So therefore, they have a revised, they have a pay structure. And in this pay structure, it has to be fitted in these. So
No.
here he has to be fitted where?
Yes, Lordship.
Where will you fit him?
Lordship, herein the grade pay, Lordship will have to see, Lordship.
Hmm.
The grade pay of 2,900, it's not here in this pay structure, Lordship, but then that is the grade pay, Lordship, which is being given to the stenographer grade pay. Because subsequent amendments were made, Lordship, and that. grade
But
pay-
2,400 became 2,900.
Yes, Lordship,
But there is no 2,400 also.
it's not there, Lordship.
So the grade pay couldn't also be 2,400.
It has to be 2,900. That was considered by the anomaly committee. And
So
subsequently-
therefore, when you are newly appointed, your pay scale has to be started from 5,200. Number 5.
Lordship.
5,200 says about a grade pay of 1,900. Yes, tell me where am I wrong?
No, my lordship is correct.
I am not correct. This is the worst thing which I find. A is one of the worst matters which is there, and he always comes up. And today I have to finish it off. No more of
No,
this
no,
matter.
Lordship, regard to the similarly situated person, may I say that, Lordship?
Ah, please.
Lordship, at paragraph 18 of my writ petition, Lordship,
Of your
of my writ petition, Lordship. Paragraph 18.
yes.
That-
That there were difference in pay of the year who were appointed along with the petitioner in different districts for some, but later on all the the stenographer bid pay as a fourth pay. Presented the pay in conformity with the pay. Including respective reported to no damage at the benefit. The piece. Yes. Now, you were referring to some document of your additional affidavit. What is this?
Additional
Come to that point.
page 122, running page 122 and 123.
Which
My lord,
reference to I am to inform you that the letter received or issued by receiver. However, regarding the initial fixation of stenography which was joined on the night before publication, action may be taken as per proviso 5 of the notification. Proviso 5 of the notification. Save as otherwise provided in this government employee who is in service on 31st of March or who have been appointed on or after shall draw pay in the revised pay structure. Pay back with great pay applicable to the post service which he have been holding or to which he may have been appointed as the case may be. Who is in service on 31st of March or who enters service here but before the date of publication of the rule may at his option continue to draw the pay in the existing pay structure until the date on which he earns his next or in subsequent increment in the existing pay structure or until he vacates his. Now, what has happened here?
This was under ROP 2017 lordship. The pay was protected lordship. That is the basic thing here in lordship.
Is protected means
Means once who were appointed prior to the publications of these rules, their pay has to be protected under this provision lordship.
meaning thereby? How
Meaning
is it to
thereby,
be
if he
protected?
is getting one pay lordship, that he will continue to receive lordship.
Irrespective of wrong fixation.
Wrong means.
If it is wrongly fixed, yes, a person normally, if he is getting a higher pay,
Lordship.
if he is getting a higher pay, then in that regard, but subsequently because of the rules, his pay is reduced. Then in that case, his pay has to be in accordance with that.
Statement lordship, that the fixation under this ROP 2010 is wrong, is where is that statement lordship from the respondent?
That is there. They categorically say that you couldn't have been added into the multiplied by 1.86.
But what about that fitment table 10 lordship, if that is wrong lordship? That fitment table is wrong lordship,
Which one?
that which is at page 114 lordship.
No. That is not wrong. That is right. But those who come prior to 2010, that is their specific case. You see, after this, it would amount to, as per the pay fixation has to be done as per the said table 1 to 15. Now in 1 to 15, how they did it? If they have done it out there to that effect, how they have fixed the stenographer table, I'll ask him now. That is another aspect. But he says that there could not have been a multiplication in respect to those persons who were appointed after 2010. And therefore, the fitment factor of 1.86 could not have been applied in the case of 3850 into 12. It could have been applied only, therefore 1.86 is being given. And if you multiply 3850 into 1.86, then it comes to 7160 and it is being rounded out to 7170. So therefore you have this revised pay band for the promotional. This is why they say. But I am only concerned is, then what is the factor? What is the relevant table for those appointed after 2010? Because there is 1 to 15. Where do these people enter the stenographer grade 3? Answer that.
Lordship, that he will answer, Lordship. I
Ah.
don't have it now. But with regard to that paragraph 18 that Lordship just read, in their affidavit, they gave a reply to that at paragraph 11, Lordship. There is no denial with respect to the appointments which were made along with the petitioner, Lordship, that they were receiving that pay, Lordship.
32,500,
Yes, Lordship.
700.
Yes, yes, Lordship.
They were given the grade pay of 7,400 plus so and so.
Yes, Lordship. Now, Lordship, if they do not deny it, Lordship, they say that others are receiving that pay only, pay as per that fixation only, Lordship. Then, Lordship, this Lordship, this calculation, which I had annexed in the affidavit in reply, Lordship,
Where page?
page 128, Lordship. Matter discussed with FA, an examination of fitment table 10 of ROP 2010 and fitment table 1.10 of ROP 2017 indicate that the basic pay in respect of stenographer grade 3, which was rupees 10,380, 7170 plus 2900 GP of plus 310 increment 3% was revised to rupees 27,990. PB 14,000 to 49,000 grade pay, 7,400 modified table 6.8.8. In this context, the fixation of pay as done by the Registry of Guwahati High Court by the office memorandum number so and so dated 16/7/2019 appears to be in order. This page 48.
Now kindly come to page 131. This is relevant. This is by the finance, I suppose.
Yes, Lordship.
Method discussed with FNA, an examination of the fitment table 10 of ROP 2010 and fitment table of year indicate that the basic pay in respect of the stenographer grade 3, which was rupees 10,380. So it comes to 10,600 is in like this, 7,170 plus 2,900 plus 310. Okay. Was revised to 27,990 plus grade pay of Iman modified table 6.10. In this context, the fixation of pay as done by the registry of the Guwahati appears to be in order. Department may, perhaps with the approval of the error, inform the district and session judge.
Yes, Lordship. Then my fixation has to be in that revised pay scale of 27,990, Lordship.
So you say that because earlier, prior to that, if you see that page 130, this is relevant. However, confusion has arisen due to the GHC order number so and so, wherein fixation of pay in respect of stenographer grade 3 appointed during the year 2016 was made. Now the department may perhaps move the finance department for their views on the matter and clarify the refixation of the initial pay of the stenographer as sought for, submitted for further order. Now, this is what has come from the Joint Secretary at page 131.
Lordship.
This is Joint Secretary from Finance.
Not,
Hmm?
it's not from finance, Lordship.
It's from the judicial
A
department.
financial advisor of the judicial department, Lordship.
FA.
So finance has not given anything.
Finance, Lordship, they simply, because they did not take any stand with regard. Finance just simply said that it has to be as per that provision 5 of that 2017 rules. Provision 5, Lordship. And ultimately what had happened, Lordship, they referred it to the judicial department, Lordship.
So the judicial department has said okay.
Judicial department said earlier only in 2020, they said.
Yes, so Mr. Barbuje, what is this?
Lordship will see this letter, Lordship.
Enough. Finish. No more. Now, Mr. Barbuje.
Lordship, may I please?
No more. Any judgment?
Yes, Lord.
Judgment.
Now, Lordship, I will be inviting my lords to the averments made in the affidavit where we have entirely laid down. Steadily, I will draw my lord's attention as well as to the annexes. Things will be clear. Now, my lord, I understand that the petitioner has not challenged his appointment letter whereby, my lord, the scale of pay was granted to him. He has neither challenged the provisions of the ROP, nor challenged the office memorandum, nor challenged any decision of the, my lord, government. What he has, my lord, claimed is the application, how it is to be applied. And with that regard, the prayer in the writ petition, Lordship will kindly see, my lord. I will go by that parameters, my lord. Now, he is challenging, my lord, that finance department's clarification, my lord, with regard to that fixation of pay. 27,000 could not have been given, it should be 21,000. That is his challenge. So the application of the rules, application, how it is to be applied, how the pay is to be, my lord, deduced, that is, my lord, his basic claim. He accepts everything, whatever is there only. He accepts the law, he accepts the office memorandum. Having said so, my lord, let us now see, my lord, my affidavit. Lordship may kindly come to running page 77. I will steadily, my lord, invite my lord's attention to this paragraph. This will make the things clear. My lord, page 77, paragraph 4 of my affidavit in opposition. My lord, that with regard to so-and-so, petition from the, it is seen that the petitioner was appointed in the post of stenographer grade 3 on 21/9/2016 and she joined on 22/9/2016. Then next page. The Assam Services Revision of Pay Rules 2017 was published on 17/3/2017. It came into force with effect from 1/4/2016. Thus, it appears that the petitioner was appointed between the date of publication of ROP 2017, that is 17/3/2017, and the date of effect of ROP so-and-so in the pay scale of pay band 2 5200 to 20,000 and the grade pay of 2,900 in the minor scale provided by ROP 2010. So she was appointed in this pay scale and she has happily accepted it. Therefore, the petitioner's pay should have been fixed as per ROP 2010. That is the pay structure of PB2, 5,000 so and so, which was applicable at the time of her joining. So her pay should have been arrived at rupees 8,100. So this is 5,200 plus 2,900. The corresponding revised pay of 5,200 to so and so is 14,000 to 70,000 plus grade pay of 7,400 as per ROP 2017. So after publication of ROP 2017 on 17/3/2017, her pay should have been refixed at rupees 21,400. This is what, my lord, we have clarified. How, my lord? 14,000 plus 7,400 with effect from her date of joining 22/9/2016. But it was erroneously refixed at rupees 27,990 by the Office of the Joint Registrar Finance, Guwahati High Court, white letter dated so and so, annexure 12 to the writ petition.
Accordingly, the Office of the District and Session Judge Nagaon, by order dated so and so, refixed her pay at rupees 27,990 as seen at Annexure 15 of the writ petition. It may be mentioned here that the pay structure
So
of.
she was given from 20,590,
Absolutely, this is the
not
pay.
14,000.
Yes, this is the pay scale which was my lord, reflected in the advertisement and also my lord in the appointment letter, which she have happily accepted. It may be mentioned here that the pay structure of stenographer grade 3 as per ROP 2010 is payable to rupees 5,200 to 20,200 plus GP of 2,900. P revised pay scale as per ROP 1998, which is 3850 to 7350. This is where my lordship was posing a question. How this 38? This is again my lord prior to 2010.
In 1998.
1998, my lord.
Fifth pay commission.
Yeah, these are my lord gradual my lord sequence, my lord.
So this was the 5,200 to 20,200 is for the sixth pay.
Yes.
And this was the fifth pay,
Fifth pay.
3850 to 7.
Absolutely, absolutely.
So
Then-
this was revised to this.
Absolutely. Then further, what my affidavit says. As per Office Memorandum also so and so dated 28/7/2007, Lordship has just now perused. The Government in Finance PRU Department laid down 15 grade pay corresponding to 15 numbers of pre-revised pay scale as direct entry pay scales. This pay structure will only be applicable at the time of entry in service of those government servants on or after 4/2/2010, which Lordship has my lord presented. The above mentioned pays were only meant for the directly recruit posts. In the aforesaid OM dated to 28/7/2010, the grade pay of 2,900 corresponding pre-revised pay scale of which is 3850 so and so was not included, as this pay scale was meant for promotional posts. So my lord, at one point of time, I enter into service as stenographer grade 3, perhaps in the my lord at the time of at the year my lord 1998 when my lord this post
No,
pay.
no, if you see, it will come under A.
A.
If you multiply 3850 with the fitment factor of 1.86, which you find,
Yes.
it is 7170.
Yes,
That is why
now
you say.
the explanation is
So
there.
it is A,
Yes,
but he comes under B.
yes.
So
So there,
my therefore question was, where do you find 3850?
the explanation is here, my lord. I'm reading it. In the aforesaid OM so and so is not made. Now the petitioner was recruited in the pay scale of so and so on 22/9/2016. Her pay was erroneously fixed at 7170 plus 2900, the 10,070, which was not even in her minor advertisement as well as so and so. The amount of 7170 was derived by multiplying the minimum of pre-revised pay with the multiplying factor of 1.86. 3850 into 1.86, that is 7161, rounded off to rupees 7170.
So
This-
how does this 7170 come for this petitioner? Because of the fitment factor 10,
Yes.
3850 becomes 7170.
Yes, which ought not to have been done. Which ought not to have been done. This fixation is not as per ROP 2010 rules, since the pay scale of 38507350 is not included in the OM dated so and so. Therefore, the petitioner is not entitled to the multiplying factor of 1.86. This is admissible only to those employees who were already in service on 31/12/2005. That is, before the date of effect of ROP 2010, which is 1/1/2006. Since the petitioner was recruited after the effect of Assam Service Revision of Pay Rules 2017, that is 1/4/2016, as such, her pay is to be fixed as per Assam Service Revision of Pay Rules 2017, that is pay in the pay band plus grade pay is equal to 14,000 plus 7,400 is equal to
That
minus.
I've understood,
Yes,
but,
this one.
but Mr. Babu, tell me how that. If 1 to 15
Man,
of the pay band in the B, finally come to page this one, 91.
Page 91, yes, my lord.
If 3850 is not there,
Yes, we say because this OM.
where will somebody enter here?
No,
Means,
because
how do you give him that
No, we say this OM is not, although we have since they have made a mention of this OM. So therefore, we have annexed this OM to show this OM is not applicable in the case of the petitioner because this is meant for only promotional post. So let us
No,
not
no,
bring,
but this is for direct recruit is this,
yes,
number 2.
no, direct recruit, but in the present case, my lord, petitioner was directly recruited, but this table at page 91, this is meant only for the promotional post.
No, number 2.
Number 2. My lord,
Pay structure for future recruits,
page,
page 90.
yes, pay structure for future recruits who entered service of the government on or after 4th of February 2010. The following pay structure shall be applicable for aforesaid category of employee. It shall consist of 15 grades. Therefore, my lord, this pay structure, this 15 grades, my lord, this 15 grades, my lord, this, the earlier was, my lord, 1998 ROP. So we have to make a continuation. That is not found, my lord, here.
So if it is not found means how do you bring them?
No,
Because of this.
therefore, we will.
Now, are you bringing it
Yes.
on the basis of this ROP 2010
Yes.
PB2, where the pre-revised was 3850 and 7350 had become 5,200 plus grade pay of this.
Yes, so she will be entitled. And therefore, my lord, I have initially submitted that she has accepted her appointment. We will have to go by what was the scale of pay that was given to her in terms of her appointment.
So this 5,200 to 20,020,
Yes,
200
yes,
has become 14,000 plus 7,000 to 70,000 with grade pay of 7,400.
absolutely.
So therefore 14,000 plus 7,400 is 20,000,
Yes, that's
21,000.
now it is 7 pay commission. Thereafter, after 5 years, it will be 8 pay commission. She will be entitled, my lord, for the increment. It is her own calculation that it should be this one, it should be this one. The permutation and combination has been created by the petitioner without making any challenge to any of the provisions of law. And kindly see thereafter, my lord. Now, so far as Azizul Haq Chaudhary, that my lord, page 122, which lordship was referring. What is the explanation? Kindly see, my lord. Lordship may for a moment again come to my lord and traveling my lord with these pages. His affidavit in reply. My lord, page 123. Now, application of the revised pay, that note 5. Save has otherwise provided in these rules a government employee who is in service on 31st March 2016. That means 1 day benefit is given, or who may have been appointed on or after 1st April 2016. She was appointed in the month of September 2016. Shall draw pay in the revised pay structure, payment with grade pay applicable to post service which he has been holding or to which he may have been appointed as the case may be. So the pay scale to which she was appointed, that will continue. And whatever
As
increment.
per 5,200
Yes, yes,
which became
yes,
14,000 to a year.
yes. Now,
Now, see the proviso provided that a government employee who is in service on 31st of March 2016
my lord,
or who enters into service on or in month but before the date of publication of the rule
may at his option continue to draw the pay in the existing pay structure until the date on which he earned his next or subsequent
Now,
increment.
these, Mr.
This
Sharma,
is with regard to MSCP increment.
no, this is for this. I remember note 2 of rule 11, isn't it?
Yes.
Where there is an option being given that when a person is similar to that, a person who is rule 11 relates to promotion.
Yes,
When a person is being promoted to a particular post, he can keep his scale of pay and say that kindly give me the increment
yes,
and don't increase it now plus grade pay. And thereafter, later on, when the next, after that increment is given on 1st of July,
yes.
which is being given,
Yes.
after the increment is given, then you will get it with the increased grade pay and everything.
Increase get pay plus back notional benefits.
This
That is
is,
the-
as
that
per
is
that.
the
This is why this is.
Basic my lord idea for bringing this note.
Because if you see rule 11, that day I got it somewhere. That day I was delivering on, you were there? No. Somebody else was there. That day I delivered one judgment on this. Here's some employee out there, her name was, he was appointed as LDA and then he became a UDA. And UDA, he became in 2016. He took the grade pay, took the increment.
Lordship, that
he-
means this provision is not applicable in my case. This provision is not applicable in my case.
No, he
Then
realized-
Lordship. Then Lordship may kindly turn to page 122, Lordship. In the second paragraph, Lordship, they have.
Regarding the
categorically stated-
initial fixation of salary of the stenographer grade 3 who have joined, before Iman, action may be taken as per proviso so and so.
And how they made it applicable. They are contradicting these statements, Lordship.
No,
At
this
one
is-
time, they
this
say that this is not
with regard to
applicable.
some other person, which have been
No, no,
replied
no.
here, my lord. Kindly
It's
see
a
paragraph
categorical
5.
statement herein made in page one
No, my lord,
twenty-two.
when I am submitting, my
Page
lord,
one
why he is
twenty-two is their
interfering?
communication, Lordship, and therein they have categorically stated that grade 3 stenographers are entitled benefits as per this provision, Lordship.
No, the fact remains this. Your scale of pay was 3850 with a corresponding to 7, which now corresponds to 5,200 to 20,020.
That's their statement, Lordship. And
No, isn't it as per the what you call the ROP, the 6 pay commission?
no,
Where you-
what was the requirement of that fitment table 10, Lordship? That fitment table 10 has been referred to in the notification of the Guwahati High Court, wherein the fixation was made in respect of all the grade 3 stenographers who were appointed along with the petitioners. And subsequently, that was made by the judicial department, Lordship. Now, Lordship, suppose even it is said that the judicial department is wrong, then can the government speak in two voices, Lordship? One thing, Lordship, he ultimately referred it to the judicial department,
No,
Lordship.
but these are only notes. These are all notes.
But
These are
then,
not
Lordship,
reduced into by
kindly turn to page 48 once, Lordship. That is the notification that has been referred to, Lordship.
page.
Page 48.
Yes.
In those notes, Lordship, this notification has been referred to. And this notification specifically relates to the grade 3 stenographers who were appointed along with me. And they are enjoying this benefit of this grade pay and all, Lordship. Under the ROP 2010, it's been specified, Lordship, that the pay was to be fixed at 7170 plus grade pay of 2900. And subsequently, Lordship, under the 7th pay commission, Lordship, it's we fixed at 27,990. Now, I have been singled out, Lordship. Others are receiving this pay, Lordship. Even, Lordship, the stenographer grade 3 who is working under CJM Nogam, who is receiving salary from the same treasury, Lordship, is receiving pay in this pay scale, Lordship. And I have been deprived, Lordship. The same treasury is, there is a discrepancy with regard. to
Just come to page
disbursal of their
48.
pay.
Pay band 5,200 to 20,020 plus grade pay of 2,900 is 7,170 plus grade pay of 2,900 with 310 advance increment.
That is the
Now,
pay-
what is this? How does 7170 come in?
That is as per fitment table 10, Lordship. That is at page 114, Lordship. That I am referring to, Lordship. Already I have referred to, Lordship. That fitment table has to be applied, Lordship. Otherwise, that pay won't come, Lordship. Now, let him say, Lordship, where this, in this office memorandum also, this pay is not appearing, Lordship.
Hmm?
In this office memorandum also, although the pay scales are given for the new recruits, Lordship, this pay band is not there, Lordship. Now, where does he get that figure, Lordship? 5,200, Lordship. Because it's not there in the office memorandum, Lordship. if that has to be applied, there must be something, Lordship, and that is not there, Lordship. I'm showing here how it is applying, Lordship,
So if it is not there
Lordship.
in the 2010, they have referred to this, na, page 91. This
Yes.
pay structure,
Page 91, yes, Lordship. It's
okay,
not there.
this is for pay structure for everybody.
For the new recruits, Lordship.
Huh? These new recruits, these are all given in PB1, PB2, PB3, and PB4.
Yes, Lord.
Now here, 3850 is not there.
It's not there, Lordship. How they are applying them? There has to be some basis, Lordship.
So this cannot be applied.
It cannot be, Lordship.
So therefore you say that he also said that this is not applicable.
No.
But he says that 5,200 corresponding AI is, he says 3850's corresponding payment was 5,200 plus 20,200.
Yes, Lordship. From where, Lordship? How does he apply that, Lordship?
Now he applies, I think it will be there from the ROP, the ROP 2010.
Yes, page 83. We have given a table, my lord.
Page?
Page 83. My lord, I need to submit, my lord. Let him not interrupt, my lord.
No, no, it's okay.
No, no, why he is interrupting, my lord?
No, it's okay. Don't, Mr.
No, I'm
Mr.
not
Borguzari,
agitated. No, I'm not getting
you see,
agitated.
other matters I would not, these pay matters are very complicated.
Therefore, my lord, I have to very slow and steady.
No, wait, page
Yes.
83, come to page 83.
I got it, Lordship.
So here
they
he
have
is therefore saying 3,850 to 7,000 is this. And this has become this.
Yes.
So that is what he is saying. And this is also stated at page 79, the first line. Now, therefore, your thing, 7.5, you were appointed in the scale of this one.
Yes, I have been appointed.
So your scale, one thing I am not getting it, 7170, here.
Page 81 of my affidavit.
Lordship.
So your initial appointment in view of the ROP is 2017, 5,200 to 20,200 is 14,000 plus 7,400.
Yes, Lordship, that's what I'm saying. This is the payment, Lordship. The whole payment is this, Lordship. But then fixation has to be made at a particular stage, Lordship. That Lordship will find in this fitment table, Lordship. That's what I'm pointing out, Lordship. That's the whole.
Now,
payment,
I get it.
Lordship.
Your thing is 3850 corresponding is 7170.
Yeah, the basic pay which he received in fifth pay.
In view of the fitment table.
At the initial stage, he received 3850.
You say that there is no quarrel with the fact that my scale of pay, I was appointed to the scale of pay of 5,200 to 20,200. There's no quarrel.
No.
But at the time of initial fixation, taking into account my original payment was, the scale is 3,800, which becomes 71270. 1 point, as per the fitment table number 10.
Yes, because Lordship.
So your initial basic pay, although it is in the pay band of 5,200 to so and so, your basic pay is 7170.
Yes.
And 7170's corresponding fitment table is what?
7170 corresponding table is at page 49, Lordship. under seven CPC, Lordship.
How do you say? Seven
For
one seven?
Lordship, this 7170 plus hearing grade pay that was amended later on, it has to be 2900, 7170 plus 2900, it comes to 10610, Lordship.
7170 plus 2900 070 10,070.
Lordship.
Huh?
Oh, Lordship, here in the explanation given by the respondent is there, Lordship. Wow. They made out the calculation, Lordship. It's not that amount, Lordship,
Plus
but they have rounded
plus
it up.
380.
They have
Now,
rounded it up.
how do you make it? It is only 10,070.
Lordship.
Yes, page 79. Page 79, my lord,
They have
of my affidavit.
rounded it up.
Page 79, my lord. Fifth paragraph.
10,070.
Yes,
Lordship.
Then how do you bring in 27,900?
That
There's-
is not there in the fitment table of this ROP rules 2010,
Yeah.
Lordship. That's where they are taking the benefit, Lordship. And that is why this notification at page 48 came in, Lordship.
Page?
Page 48.
we
No,
say,
no, 48 has no business.
yes,
Yes,
we
yes,
say
Lordship,
that
it has-
by-
No,
by-
Mr. Sharma, 48 cannot be said to have any business. We'll come back.
Lordship.
Well, no, item number 13, 41, little bit confusion is there, my lord, about that settlement. Neither he's getting instruction properly. I'm just one big time, lordship. One.
The report, Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner submits that Mr. N. The learned counsel appearing on behalf of the respondent submits that the matter have been amicably settled. Mr. S. Samaria appearing on behalf of the petitioner submits that he would obtain instructions in that
Right.
regard. This matter again on. Take it, eh?
After 10 days, my lord. we'll go.
Okay. Okay, just take again on 27th of
My
May,
lord. This one.
26th of May.
26 of
Calculation, this is a representation which is at page 45, Lordship. It's appearing there in Lordship.
Mr. Sharma, tell me one thing.
Lordship.
When you are appointed against the post, against the pay scale, the pay scale is giving, just for here, the pay scale is 5,200 to 20,220.
Hmm.
Then your salary would be, the basic pay would be 5,200 or any other.
That's what, Lordship. Lordship, may I kindly have a look at these fitment tables once?
The
Lordship?
fitment table will go into that.
Yes, Lordship. Why I'm saying so, because grade pay plays a different role in this, under this ROP rules 2010. Herein, in the same pay band that is of 5,200 to 20,200, herein, Lordship, if the grade pay is 1,800, then Lordship, the pay would, under these fitment tables, that would be of 5,200, Lordship. Subsequently, if the grade pay is 1,900, then the pay also is 5,200 under fitment table 5. Then there are subsequent fitment tables, Lordship, wherein the grade pay, if it enhances, then the basic pay upon entering into that service is higher, Lordship. So this goes on, Lordship. From fitment table 4 onwards, that pay band of
Now,
5.
you were appointed at 5,200 with grade pay of 2,500, 900.
Yes, Lord.
So as per the fitment table, how much should it be?
As per that fitment table 10, Lordship, it ought to have been 7,170, Lordship.
Would be that.
Yes.
So your initial pay will start at 7,170.
Lordship. Fitment table 10 lordship. The prior pages, lordship will find the earlier fitment tables, lordship, wherein the gate pay is lower. Lordship. On using those, lordship may draw an analogy that upon if I get a higher grade pay, lordship, the fixation is to be made at a higher point of a time. From fitment table 4 onwards, lordship will find a pay band, lordship, of that 5,200 to the grade pay is lower than the right hand side upper portion, lordship will find it.
Okay, now I get it.
Lordship,
You see, now what they have done,
lordship,
5,200 is in various other scales.
lordship,
It starts from pay scale of 2,610 to 4,480,
lordship,
and it ends at 3,850 to 8,760. Isn't it?
yes, lordship,
Now, the grade pay of your was 3,850 to 7,350. So the
That's correct.
revised pay scale, although it is in 5,200 to 20,200, but the revised pay band would be 7,170,
lordship.
isn't it?
That is not the case here, because his appointment letter shows, my lord, kindly see, my lord, page 39. It is a newly created post, kindly see. In pursuance of page 39 of the writ petition I am reading, in pursuance of the notification of Guwahati High Court, so and so, the Doity data petitioner is hereby temporarily appointed as stenographer grade 3 in the establishment of the undersigned against the newly created post of stenographer grade 3 by government creation letter number so and so dated 29/5/2015. Lordship will kindly mark this 29/5/2015. So in 29/5/2015, what was the what was the my lord, pay my lord, granted by the then pay commission? It is, my lord, 2010. 2010. So 2010, in 2010, my lord, pay commission's recommendation, which find, my lord, placed in the ROP rules of 2010, 6 pay commission. This 3850 was not there. 3850 pertains to the earlier, my lord, pay commission, my lord, ROP of 1998. So therefore, we cannot apply that 1998 pay structure and multiply it with 1.86. That is the mistake which they have done. It could not be. It
No,
cannot be.
no. This is not multiplication. Now, what has happened is this. You see, 5,200, that is why I'm saying.
Yes.
This pay scale of 5,200 to 20,200
Yes,
is given to various pay scales.
various pay scales and
Starting from, no, starting from, see, starting from,
Fitment table 4.
starting from 2,610 to 4,840.
Yes.
is the first, which has then been revised to 5,200 to 20,200. Okay, so this also becomes 5,200 to 20,200. And 3,850 to 7,350 is the corresponding scale for stenographer grade 3.
Maybe at that earlier point of time.
Yes.
But this, my lord, as per ROP 2010, the pay scale for stenographer grade 3 was, my lord, calculated and incorporated in the ROP in pursuance of Safety Commission recommendation.
Understood, but
Yeah.
whatever may be,
So we
if
will
you
have
see
to-
this, na, then you get the idea.
I have seen this. It is a part of, my lord, page 114.
No, 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 no. That is why I'm saying. You see this slide. Meaning thereby, what you are saying, if we take it in this manner, as per you,
Yes.
then you have to put the stenographer grade 3 scale
Yes.
at 2,600.
No, we have to start the journey from when he was appointed. Let us not be
Understood, but he has to get, because the fitment factor at that point of time was 7,170.
let us not go to that fitment factor. He was appointed, he had accepted his appointment, she has accepted her appointment, my lord, the petitioner. And having accepted her appointment, my lord, she cannot now resign that, no, I ought to have been granted more pay, more money because this is the calculation. This has
No,
to
no,
be
no, no,
applied.
no, no. He is not saying that. He says that, yes, I am in the right pay band.
Yes.
I'm in the right pay band, right pay scale, everything is right. There's no quarrel with that.
Yes.
He says that my pay scale should start from 7,170 because it falls within it, because the corresponding was 3,850.
Yes, we cannot relate it to 3850.
Because if you don't relate it,
Yes.
then you are giving the scale, the previous scale at 2,610.
No, not 2000. Therefore, because that 3850, therefore, my lord, this office memorandum, why we have annexed it along with our affidavit to show, my lord, that first of all, 3850 doesn't figure there. And then secondly, my lord, this 3850, my lord, that OM, that OM is applicable only for promotional posts. Petitioner has been directly recruited. See, it is not a case that, my lord, she has come into service on promotion as on.
Are you saying
Yes.
that there cannot be a fitment table for, because what you are trying to do is, you are rendering the scale of stenographer to 2,610.
2610, no, my lord.
Yes. No, no, no.
Only-
See that. Because 2,610, 2,610 to 5,000 a year is also 5,200 to 20,220. 200. And this happens for 7 or 8.
Therefore, my lord, it is not the case of the petitioner that 2650 is to be applicable. Is
No.
to be made applicable. See,
He
see,
says that the scale of pay for stenographer grade 3 as per the fitment and as per the stenographer here is 3,850.
3,850 as per ROP 1998. Now, in the year when ROP 1998 was applicable, my lord, she was not in service. She came into service in the month of, my lord, 21/9/2016, when ROP 2017 was very much in force, my lord. But her appointment letter, my lord, my lord, mentions about, my lord, the ROP of the scale that is given in ROP 2010. Might be because the process was initiated, my lord, maybe from an ante point of time. So the figure, that is the table, the comparative table which we have mentioned at running page 83 of my affidavit, the pay scale which was provided as per ROP 2010 was granted to her as per the terms of her appointment, and she accepted it. What would be the corresponding? Definitely on revision of pay as per 7th Pay Commission, which is ROP 2017, she will get more money. And what will be the more money, my lord? This is the calculation. This is the calculation at page 83. Now, while doing so, my lord, this figure, therefore, my lord, lordship will kindly again, my lord, come to my lord, page 78 of my affidavit, how this miscalculation has been done.
Yes.
Page 78, from the beginning, again I am reading, madam. ROP 2017 was published on 17/3/2017. It came into force on 1/4/2016. Thus, it appears that the petitioner was appointed between the date of publication of ROP and the date of effect in the pay scale of so-and-so. Now, this is the pay scale which is applicable for ROP 2010. Because of the reason, my lord, it was granted to her and she has accepted. Now, she cannot challenge it, my lord.
She is not challenging there.
Therefore, we are now to apply. We are now to apply. This is the basic pay scale. She has accepted it. Now let us apply it. How it is to be applied, kindly see. Therefore, the petitioner's pay should have been fixed as per ROP 10. That is in the payment structure of 5200 20,200 plus grade pay of 2,900. Very much correct, which was applicable at the time of her joining. So her pay should have been arrived at 8,100. That is 5,200 plus 2,900. Next paragraph. The corresponding revised pay of rupees 5,200 to 20,000 so and so GP is rupees 14,000 to 70,000 plus grade pay of 7,400 as per ROP 2017. So after publication of ROP of 2017, her pay should have been refixed at rupees 21,400. That means 14,000. Now, what is 14,000? 14,000 is the first figure in the payment. 14,000 to 70,000 plus 7,400 with effect from her date of joining. And 7,400, what was 7,400? 7,400 is the grade pay. So 7,400 plus 14,000. It comes to 21,400 with effect from her date of joining 22/9/2016. Now, what is the error that has been committed? But it was erroneously refixed at rupees 27,990 by the Office of the Joint Register Finance, Guwahati High Court, by letter dated so and so. Accordingly, the Office of the District and Session Judge, Nagaon, by order dated so and so, refixed her pay at 27,990 as seen at Annexure 15 of the writ petition. It may be mentioned here that the pay structure of stenographer grade 3 as per ROP 10 is payment to rupees 5,200 to so and so. Pre-revised, Lordship will kindly mark this, pre-revised pay scale as per ROP 1998 of which is 3850 to 7350. Till now we are clear. As per OM dated so and so, 2010, the government in finance PRU department laid down 5 grade pay, 15 grade pay corresponding to 15 numbers of pre-revised pay scale as direct entry pay scale. This pay structure will only be applicable at the time of entry in service of those government servants on or after 4/2/2010. She would have might have got it, but she didn't get. What is the reason? The above mentioned pays were only made for directly recruited posts. In the aforesaid OM dated 2010, the grade pay of 2,900 corresponding pre-revised pay scale of which is so and so 3850 was not included as this pay scale was meant for promotional posts. Now the petitioner was recruited in the pay scale of payment to so and so. Her pay was erroneously fixed at
As this pay scale was meant for promotional post. How do you say so? When the post of the stenographer grade 3 is for direct recruit?
direct recruitment, but that figure doesn't get mentioned in that OM. It is not there in that OM. So if it is not there in the OM, we have to have a source. The source is not there. How can we apply? When the source is not there, how can we apply? It is
So
as
therefore,
simple.
that OM does not apply.
Apply.
Then
Yes, then now the petitioner was recruited in the pay scale of PB2 so and so on 22/9/2016. Her pay was erroneously fixed at 7,170 plus 2,900 is equal to rupees 10,070. Lordship has made that calculation. The amount of rupees 7,170 was derived by multiplying the minimum of pre-revised with the multiplying factor of 1.3850.
no, this was actually, this is wrong. This was not done as per 7170 was not arrived on the basis of 7161. 7170 was arrived at on the basis of the fitment table number 10.
No, fitment table number 10, but by applying multiplying factor 1.86.
No, because the fitment table number 10 is given.
So fitment table number 10 is given, but fitment table will only be applicable, my lord, if someone is appointed midway. Suppose ROP 2017, here is a case, my lord, where in between ROP 2010 and ROP 2017, C came to be appointed. So the pay scale was very much well mentioned in her letter of, in the advertisement as well as in the appointment letter. So we will have to accept it. And having accepted that payment, let us now see to what extent, what will be the increment. The increment is given, my lord, here. How it will be in this page 83. Page 83.
Yes.
This is the comparison.
No, if you are saying that this corresponds to that,
Yes.
then if you
The
if you
answer is-
say that ROP 1998 is not at all applicable for the case of the petitioner, but then why are you referring to it?
no, referring to, because she has made a
Because
reference,
otherwise you are putting him in the status of a 2610.
because she has made a reference in her petition, she is claiming that pay scale, 3850. Let us not confuse. She is only mentioning the figure. Petitioner is only mentioning the figure. 3850 is gospel truth. So 3850, we have to proceed now from 3850. Now, if we proceed from 3850, why it is not applicable? Why it cannot be done? This is the explanation in my affidavit.
What is the
Yes,
explanation?
kindly see, my lord. Page 79.
No,
For a
you are
moment.
going on the basis that then they have erroneously applied clause 1 of the 2010 office memorandum. You are going on that basis.
Yes,
But not on the basis that the fitment table number 10 categorically says the 3850's corresponding basic pay is 7170.
yes, fitment table is to be applied and it is to be fitted. Let us make it as simple. My lord, pay commission is constituted, then my lord, rules are framed, then it is published. Now, 2010 rules came to be published. Thereafter, 2017. In between, C came in. Now, when C came in, my lord, then the pay scale which was given to her, my lord, in terms of her appointment, was the pay scale which was given as per ROP 2010. She has accepted it. So if there has to be any increment as per 2007, because in the meantime, 2017 has also come.
Now, when they were appointed out there,
Yes.
you were given 7170.
No,
Yes.
no.
Yes,
No,
I was
kindly see
given,
the
but
appointment letter. Kindly
subsequently
see the appointment
They
letter.
took it back.
No, appointment letter says 5,200 to 20,020.
Yes.
I'm not on that.
Yes.
But when you were appointed, you were given 7170. That is what I am saying.
Yes, she made-
Therefore, they applied not the fitment factor of 1.86, but they applied that because otherwise you are putting his scale into the same as 2610.
2610 will be a different factor, my lord.
That is what is happening because you see, there are eight pay bands which have been different pay bands which have then been brought to 5,200 to 20,000.
There may be payments, defined payments, my lord.
No. All these 7 or 8 pay bands
Yes.
which were there in 1998
Yes.
have been brought within the bracket of the pay band of 5,200 to 20,020.
Maybe, but what is the payment applicable for stenographer? We have spelled it
It
out
is
clearly.
3,850.
No, can see, my lord, ROP 1998, therefore, my lord, page 83 again. ROP 1998, the payment was 3850 to 7350. Admitted position, no doubt. Then what is their payment, my lord, in ROP 2010? From 5200 to 2900. 5200, it starts up to 20,200 and grade pay is 2,900. Then ROP 2017, 14,000 it starts, ends at rupees 70,000. This is the bracket and the grade pay is rupees 7,400. So all the increments would be applicable to her and she will be entitled to all the benefits arising out of increase in the pay scale as per ROP 2017 within that, my lord, limit, within that circumference. She
Give it to
cannot.
me. I think I have made up my mind. Petition is now necessary.
No,
I mean, allowing a petition. No more argument.
But I wanted to place one
No.
judgment. I wanted to place one judgment.
Please do. And what do you say about the judicial department's letter?
we said that it was erroneously calculated.
No,
I
the
think,
last one,
Lordship,
page
This
124.
confusion is arising because in ROP 1998, there was no grade pay, Lordship. And in ROP 2010, this grade pay came in, Lordship. And because of this great pay lordship, the fitment factor.
Yeah, what are you referring to?
Here in lordship, paragraph 3, lordship may kindly peruse.
Consider the claims of all drivers as common category under the head pay, pay scale, so and so. After considering the qualification itself and protest by the driver, the commission proposed pay scale for various categories of drivers.
Then lordship, other things are also discussed, but then paragraph 8 and 9 are also relevant herein.
What is this for?
Lordship, this matter basically relates to pay parity, lordship. Herein, all
Ah,
the-
don't come up with this paperity business.
sir, because,
You say that the promotional people should be
Yeah.
given the same one. That's it.
no, that I am not saying, lordship.
Then what do you want?
The ones who were recruited along with me are receiving a higher pay scale. That I have spelled out at paragraph 18, and in their affidavit at paragraph 11, they did not deny it, lordship. And therein, lordship, it is a categorical statement that my entry qualification on and all other things are similar to those incumbents, lordship. Herein, lordship, one thing is there, lordship, that the establishment is different. Establishment is different because,
I'm not on those. Your
And-
simple question is this, whether 27,990. Isn't it?
yes, lord,
And there should not be any further deduction.
yes, lord,
That's it.
yes.
Now, at paragraph 5 of my affidavit in opposition, I have dealt with that other person.
Hmm.
My lord, inference of whom my lord have been drawn by the my lord petitioner. That one, that Azizul Haq Chaudhary, stenographer grade 3, my lord. He was also given, my lord, that benefit, but so far as the petitioner is concerned, she was not given. So to that extent, my lord, we have made that explanation.
What is your explanation?
My lord, it says that, my lord, it could not have been done.
But you are still giving?
No, we are not giving. It is the, my lord, High Court that is giving, my lord. We are not giving. And that notes in the affidavit in reply, which he have annexed. It is not his case, my lord. My lord, in the affidavit in reply, he has now developed his case. It is not a part of the writ petition. These materials are not a part of the writ petition. Only after my filing of the affidavit, my lord, he has filed his affidavit in reply. All this treatment table business has now come in, my lord.
Huh?
After filing
That
of
is
the,
why I gave you time last time.
no, but this treatment table, whether this treatment table would be applicable or not, my lord. I say, my lord, this will not be applicable. But if I may be given an opportunity, my lord, I can file a sub reason to this affidavit because this is not a part of the writ petition.
I'm not relying on that.
Lordship. It is not a part of the writ petition, original pleading, my lord. He has developed his case after I had filed my affidavit.
No, lordship, herein, lordship, that pay, lordship, just
And
referred
his
to.
pay scales have been given, my lord, as per ROP 2010, my lord, in pursuance of City Commission recommendations. Even the
Correct.
City Commission recommendations, we have made it a part of our affidavit.
Oh, enough. The remaining is for division bench.
My lord.
Heard Mr. MP Sharma, the learned counsel appearing on behalf of the petitioner. Mr. Argo Tuzari, the
One judgment I am relying, my lord, 2010-11 SCC 694.
1000.
2010, my lord. 2010-11 SCC 694. State of West Bengal versus Subhas Kumar Chatterjee and others.
11 SCC.
Yes, 2010, 11 SCC,
Page
page 694.
6.
Here, my lord, in my Manupatra version, it is paragraph 26, my lord. Perhaps it will be there. my lord. Yet another question that arises, that is the paragraph.
Para?
My lord, the para starts at, yet another question arises for our consideration is whether a writ of mandamus lies compelling the state to act contrary to law. That matter also pertains to fixation of pay.
Alva Pujari appearing on behalf of the respondent number.
Respondent number 2, my lord, finance.
Respondent number 2, Ms. S. Sharma appears on behalf of the respondent number 3, 4, and 6. Treasury, you appear
Yes, yes, there, yeah.
2 and 5,
2 and 5, my lord.
and Ms. So and so appears for respondent number 1. Milai দিব দেই। The petitioner herein have approached this court seeking appropriate redirection and order to set aside the communications dated 11/4/2022, 16/9/2022, 28/9/2022, and further seeking appropriate directions to that effect that the petitioner should be paid his or her salary in terms with the communications dated 24/8/2018, comma 21/8/2019 and 16/7/2019. We are certain the dispute involved in the instant proceedings. It is relevant to take note of the brief facts which led to the filing of the instant writ petition. Full stop. The petition, the Guwahati High Court issued an advertisement on 12/6/2015 calling for filling up of 191 vacancies of stenographer grade 3 for the subordinate judiciary of Assam in the scale of pay of rupees 5,200-20,200 plus GP 2,900 bracket PB 2-2 plus other allowances as admissible under the rules. First, the petitioner duly participated in the said proceedings, and by the notification dated 30/7/2016, the petitioner was provisionally selected as a stenographer grade 3 in the order of merit, as per merit, on merits. Subsequent thereto, the petitioner, a notification was issued on 4th of August 2016, wherein the petitioner was allotted now, the services of the petitioner were, this is not necessary. Subsequent thereto, by an order dated 21/9/2016, the petitioner was appointed as stenographer grade 3 in the establishment of the district and session judge Nagaon against the newly created post of stenographer grade 3 in the pay band 2 bracket for rupees 5,200 - 20,200 plus GP 2,900 plus other allowances per month as admissible as per government rules with effect from the date of her joining. Subsequent thereto, on 22/9/2016, the petitioner joined as a stenographer grade 3 in the establishment of the district and session judge Nagaon. It is relevant to take note of that on 16/7/2019, the Joint Register of Finance of the Guwahati High Court had issued a communication to all concerned that in respect to the initial revised basic pay as per ROP 2010 pertaining to the pay band 5,200 - 20,200 plus GP 2,900, it would be rupees 7,170 plus 2,900 brackets GP plus 310 bracket advance increment at the rate of 3%, totaling to rupees 10,380. It was further mentioned in the said communication that as regards the initial revised pay, basic pay as per ROP 2017, pay band 14,000 - 49,000 plus GP 7,400 would be 27,990 bracket including GP of 7,400 bracket close, including GP of 7,400, that's a bracket open, modified table number 6.8.10. With effect from 21, in view of the said communication dated 16/7/2019, the petitioner's salary was accordingly refixed at rupees with basic pay of rupees 20,590 plus grade pay of 7,400 by an order of the district and session judge Nagaon dated 21/8/2019.
Benefit of this was never given now.
So the order dated 21/8/2019 was passed by the District and Session Judge Nagaon, but the petitioner was not granted the said benefit. And under such circumstances, the petitioner submitted a representation on 1/7/2020. On the basis of the said representation, the petitioner was informed by the respondent number 66, respondent number 6, that a clarification has been sought from the finance bracket PRU department, bracket close, PRU bracket close, department, government of Assam, through the LR and the secretary to the government of Assam judicial department, as regards the initial pay structure of stenographer grade 3 who joined in service on 22/9/2016, that is before publication of the ROP 2017. Full stop. Subsequent thereto, by the communication dated 11/4/2022, the Deputy Secretary to the Government of Assam Finance PRO Department issued a communication to the District and Session Judge Nagaon, providing the clarification. In terms with the said communication, which is impugned in the instant proceedings, that in terms of the said communication, which is impugned in the instant proceedings, it was stated that as OM dated 28/7/2010, the government in the finance PRO department increased the minimum of the pay in PB of 15 grade pays and refixed the pay of government servant who enters into service on or after 4/2/2010 by multiplying the minimum of the pay in the revised pay scale the said the aforementioned pay were only meant for directly recruited posts. It was also stated that in the OM dated 28/7/2010, the grade pay of 2,900 bracket pre-revised 3,850-7350 has not been included. It was also mentioned that these stenographers grade 3 were recruited after the date of effect of the Assam, AS means?
Assam Services.
Services bracket ROP rules 2017. For short, the rules of 2017. That is 1/4/2016. And as such, the pay is to be fixed as per the rules of 2017. That is pay in the PB plus GP, that is 14,000 plus 7,400 is equals to 21,400. The District and Session Judge Nagaon was therefore requested to do the needful. Pursuant thereto, the District and Session Judge informed the petitioner, Nagaon, informed the Treasury Assam that in terms with the communication dated 11/4/2022, and taking into account that the petitioner herein was drawing a higher scale of pay with effect from 22/9/2016 to 31/8/2022, and the accumulated amount was rupees 1,68,644. The said excessive amount be refunded the excessive amount be refunded through pay bill in each equal monthly installment of rupees 5,000 from the pay bill of September 2022. In other words, an amount of rupees 5,000 was required to be deducted from the pay bill of the petitioner every month towards realization of an amount of rupees 1,68,644. It is under such circumstances the petitioner has approached this court seeking appropriate directions for setting aside of certain communications referred to herein above, as well as also seeking a writ in the nature of mandamus to the effect that the petitioner is entitled to the pay in terms with the communication dated 16/7/2019. Pursuant to the filing of the instant writ petition, this court, by an order dated 15/7/2024, issued notice no stay, na?
Lordship. Yes.
No stay?
No stay.
You are deducting.
But that, my lord,
stay, no stay, lordship.
there will
There
be,
is no stay, Lordship.
Issued notice. The record reveals that the respondent number 4, that is the District and Session Judge Nagaon, had filed an affidavit in opposition from the said affidavit in opposition. It is relevant to take note of that when the petitioner, relevant to take note of, that it has been mentioned that when the petitioner joined the establishment of the District and Session Judge Nagaon on 22/9/2016 in the payment of rupees 5,200 20,200 plus GP of 2,900 and other allowances, her initial fixation, that is rupees 7,170 plus 2,900 equals to rupees 10,070 bracket close, was done in terms with the ROP 2010, as ROP 2017 was yet to be published. And with this, as per the government's letter 1 advance increment amounting to a total of rupees 10,380 was added. Full stop. It was further mentioned that the pay bill of the petitioner was prepared fixing her initial basic pay at rupees 27,990 and was submitted to the Treasury Office Nagaon, but the bill was objected and returned by the Treasury Officer office along with an objection slip dated 4/9/2019. In response to the said objection, a letter bearing a letter dated 19/9/2019 was resubmitted to the Treasury Officer Nogam, who after verification of all documents by the objection slip now dated 30/9/2019 suggested to fix the revised pay structure of the concerned incumbent or of the petitioner under Rule 8 capital A bracket, so small a bracket, as per fitment table at the appendix 1 of the revision of pay rules 2017 at page number 308 appended therein by the finance PRO department notification dated 17/3/2017. Full stop. Accordingly, the initial basic pay of the petitioner was again fixed at rupees 22,050. Full stop. Subsequently, a letter was received on 3/7/2019 sent to the Commissioner and Secretary Finance PRO Department Government of Assam seeking his or her opinion whether the initial basic pay of the petitioner was correct or not. However, no reply was received till August 2020. It was also mentioned that the petitioner had submitted representations on 6/8/2019, 1/7/2020, and 8/9/2020. The respondent number 2 had filed an affidavit in opposition. This affidavit in opposition throws light as to what the petitioner, as per the finance department, is actually entitled to. It was mentioned that the rules of 2017 was published on 17/3/2017, which came into force with effect from 1/4/2016. It was stated that the petitioner was appointed between the date of publication of the rules of 2017 and the date of coming into effect of the rules of 2017. In the scale of pay of PB2, there's rupees 5,200 20,200 plus GP 2,900 bracket ROP 2010. It was further mentioned that the petitioner's pay should have been fixed as per ROP 2010, that is in the pay structure of PB2, 5,200 20,200 plus GP 2,900, which was applicable at the time of her joining. So her pay should have been arrived at rupees 8,100. Bracket 5,200 plus 2,900, bracket close. It was further mentioned that the corresponding revised pay of rupees 5,200 20,200 plus GP 2,900 became 14,000 70,000 plus GP 7,400 as per the rules of 2017. So after the publication of the ROP, publication of the rules of 2017 on 17/3/2017, her pay should have been refixed at rupees 21,400. That is bracket 14,000 plus 7,400 with effect from her date of joining, that is 22/9/2016. But erroneously, it was fixed at rupees 27,990 by the Office of the Joint Register bracket Finance Guwahati High Court by the letter dated 16/7/2019. On the basis of an erroneous fixation by the Joint Register Finance Guwahati High Court, the District and Session Judge Nogam had passed the order on 21/8/2019, refixing the pay of the petitioner at rupees 27,990, bracket basic pay rupees 20,560 plus GP 7,400. Full stop. It was categorically mentioned in the said affidavit in opposition that the pay structure of the stenographer grade 3 as per the ROP 2010 is PB2 rupees 5,200 dash rupees 20,200 plus GP is 2,900 bracket pre-revised pay scale as per ROP 1998 of which rupees 3850 dash 7350 bracket close. In respect to the office memorandum dated 28/7/2010, it was mentioned that 15 grade pay corresponding to 15 numbers of pre-revised pay scale as direct entry pay scales were mentioned. First, however, it was further mentioned that the pay structure will be only applicable at the time of entry in the service of those government servants on or after 4/2/2010. First, it was further mentioned that in the OM dated 28/7/2010, the GP of rupees 2,900 bracket corresponding revised pre-revised pay scale of which is 3,850-37350 bracket was not included as this pay scale was meant for promotional post. First, it was further reiterated that as the petitioner was recruited in the pay scale of PB2, 5,200-20,200 plus GP 2,900 on 22/9/2016, her pay was erroneously fixed at rupees 10,070 bracket 7170 plus 2,900. And this was done by wrongly multiplying the fitment factor of 1.86 to rupees 3,850 and rounded off to rupees 7,170. It was also mentioned that the fitment factor, it was also mentioned that the multiplying by the fitment factor of 1.86 would have only be permissible in respect to those persons who were appointed prior to 31/12/2005, as would be seen in clause 1 of the office memorandum dated 28/7/2010. At paragraph number 7 of the said affidavit, being relevant, is reproduced herein under. From above quoted paragraph, it would be seen that it is the specific stand of the respondents of the finance department that the pay scale of the petitioner and similarly placed stenographer grade 3 is as per the recommendation of the SETI Commission, which recommended the pay scale at rupees 3,800-7350. First, at paragraph number 14 of the said affidavit in opposition, it was mentioned that the District and Session Judge Kamrup Metro by the letter dated 7/9/2022, forwarded an application of one Azizul Haq Chaudhary seeking review of the government's letter dated 11/4/2022. It was mentioned that the Finance PRO department had examined the matter on various occasions and by letter dated 11/4/2000, is it the same date? How is it possible?
Should be my note. 15.
12/4.
12.
But by the letter dated 12/4/2022, the office of the district and session judge was requested 24.
24.
The office of the district and session judge Nagaon was requested to fix the pay of AI as per ROP, and then by letter dated 15/12/2022. No, it was 15/12. 15/12 বুলি কৈ দিওঁ। Examined several times, and the matter was examined in the Finance PRO department, and by the communication dated 15/12/2022.
At page 101, annex some typographical mistake.
15/12/2022.
Yes. Page 101.
It was mentioned that Sri Azizul Haq Chaudhary would be entitled to fixation of the pay as per ROP rules of 2017, that is pay in PB plus GP bracket 14,000 plus 7,400. Isn't that?
Yes.
Justo. It is further seen that by another communication dated 12th of April 2024, the Undersecretary to the Government of Assam Finance PRO Department has also further informed the Deputy Secretary to the Government of Assam Judicial Department that the District and Session Judge Nagaon, Kamrup Metro, that the District and Session Judge Nagaon was informed by the communication dated 15/12/2022 to fix Sri Azizul Haq Chaudhary as per the rules of 2017. The record reveals there is an additional affidavit which was filed by the petitioner subsequent to the affidavit in opposition filed by the respondent number 2. In the said affidavit in opposition, the petitioner had brought in the fitment table number 10, as well as a notification dated 19/2/2011. The fitment table number 10 was brought in to show as to how the amount of rupees 3,850, as to how the basic pay of rupees 3,850 was revised to rupees 7,170. The notification dated 19/2/2011 was brought on record to show that the grade pay of rupees 2,400 was made 2,900, was revised to grade pay of rupees 2,900. Further to that, a communication dated 16/3/2022 was brought on record to show that the finance PRO department had written a letter to the Azizul Haq Chaudhary has been mentioned that initial fixation of salary of stenographer grade 3 who joined in the year 2016 before publication of the ROP 2017 action 2017, action may be taken as per the proviso of the notification by notification number 17/3/2017. These are old ones, 2020. They have written latest letters in 2022. The other things which you are referring to, all these other things which are there in 2022, all these things, they have written a letter in respect of Azizul on 15/12/2022. So these office notes which you are referring to are prior to that.
Yes, Lord.
So it has no relevance.
I just said that they.
No more. I'm coming back. No more, no more. Counsel appearing on behalf of the petitioner submitted. In the backdrop of the pleadings, let this court now take note of the submissions made by the learned counsel for the parties. Mr. M.P. Sharma, the learned counsel appearing on behalf of the petitioner submitted that the materials on record will show that the SETI Commission's recommendation have been duly accepted in respect to the pay scale of the stenographer grade 3, which is rupees 3,000, which is in the pay scale of rupees 3,800 and where is that
3850
page?
page 70, page 94, Lord.
Which is as per, which is at
97.
the pay scale of rupees 3,850-7350. Full stop. He submitted that a perusal of the ROP 2010 would show that the various pay scales ranging from, where's the book? Ranging from various pay scales pay scales as per ROP 1998, ranging from 2,600 dash 4,840 with to 3,580 dash 8,750 were brought within the purview of the revised pay scale of rupees 5,200 to 20,200. With different grade pays ranging from 1,800 to 2,800. The learned counsel further referred to the notification dated 19/2/2011 as to how the grade pays of post in pay band 1 and 2 was enhanced. He submitted that as per the revised pay scale in terms with ROP 2010, pertaining to stenographer grade 3, which was 5,200 to 20,200, with grade pay of 2,400, was enhanced to grade pay of 2,900. The learned counsel therefore submitted that in the fitment table number 10, it would be seen that in respect to pre-revised scale of rupees 3,850 to 7,350 with the revised pay band of bracket PB2 plus grade pay was rupees 5,200 - 20,200. The learned counsel further submitted that the initial therefore submitted that the basic pay of the pre-revised scale of rupees 3,850 was revised in the running pay band to rupees 7,170. He therefore submitted that the rules of 2010 makes it very clear that in respect to those persons who have, in respect to the pre-revised pay scale of 3,850 to 7,350, with the revised pay band of rupees 5,200 - 20,200, the basic pay of rupees 3,850 became 7,170. This being the mandate of the rules of 2010, by way of a notification or an office memorandum issued in the year 2010, issued on 28/7/2010, this very aspect could not have been modified, taking into account the settled principles of law that a statutory rule cannot be overridden by way of an office memorandum or a notification. The learned counsel further submitted that if the petitioner herein is to be given, petitioner herein salary in revised pay is to be taken on the basis of rupees 5,200 on the ground that he was appointed after in the pay band of rupees 5,200 - 20,200, comma, it would render the petitioner's salary it would amount to payment of the petitioner, fixation of the petitioner's pay at the pre-revised rate of rupees 2,610. There's 4,840, wherein the initial pay of rupees 2,600, the initial basic pay of 2,600 was revised to rupees 5,200. Anything more? No more.
No.
Per contra, Mr. Arbor Pujari, the learned counsel appearing on behalf of the petitioner submitted, a respondent, finance department submitted that the petitioner herein have not challenged the advertisement or even his appointment wherein he was appointed to a post where the pay scale was 5,200 to 20,200 with grade pay of 2,900. Taking into account that the petitioner have not challenged the advertisement as well as his appointment letter, the fixation of the petitioner's salary, revised pay, has to be taken by adding 5,200 plus grade pay of rupees 2,900, which is 8,100. He further submitted that in terms with the rules of 2017, as the pre-revised scale of pay of rupees 5,200, there's 20,200 with grade pay of rupees 2,900 became rupees 14,000, there's 70,000 with grade pay of rupees 7,400. The petitioner's salary as on the date of his appointment on 22/9/2016 should have been rupees 21,400, that is bracket rupees 14,000 plus 7,400. However, it is on a wrong calculation. The Joint Register of Finance of the Guwahati High Court had issued the communication dated 16/7/2019, and on the basis thereof, the petitioner have been granted an additional amount, which is therefore required to be recovered. Anything more?
Page 98 is a notification whereby, my lord, the existing and the revised pay has been notified in my affidavit. There,
Page
98, running page number 98. And next side D. Just to supplement, my lord, the statements made in the affidavit. Their lordship will kindly come to serial
Yeah, this
number.
is okay. There's no problem.
Yes, that's all. That much. And this fitment factor cannot be applied.
Huh?
Fitment factor cannot be applied. 1.86.
He further submitted that as the petitioner is a direct recruit, that too after 1/4/2006. 1/4/2016. No. Fitment factor was only prior to that. No? If you see
Yes,
that.
yes, 1/4/2006.
1/4/2006.
Yes. Yes, because that is the date, my lord, which by which, my lord, the sixth pay commission came into effect. My lord, the earlier 1990.
1/4/2006,
Yes.
comma. The petitioner cannot insist upon the pre-revised pay of rupees 3,850. 3,000?
3,850, 3,850.
To 7,320.
Yes, madam.
3,850 to 7,350. Full stop. Further to that, as the petitioner was appointed after 4/2/2010, comma, the question of applying the applying the 1.86 fitment factor in the case of the petitioner does not arise. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration to their relevant submission, to their respective submissions. Pusto. The learned counsel for the Finance Department further referred to a judgment of the Supreme Court in the case of State of West Bengal versus Subhas Kumar Chatterjee and others, reported in 2010, 11 SCC 694, and more particularly to paragraph number 30 to submit and to buttress his point that the state government, having accepted the recommendation of the successive pay commission and having given effect to those recommendations by framing statutory rules, being the ROPA rules, and the scales of the employees have been accordingly fixed, comma, by way of a writ of mandamus, the state cannot be asked to act contrary to law. First, I have given my anxious consideration to the respective submissions, and I have also perused the materials on report referred to herein above. First, in the affidavit of the respondent number 2, more particularly at paragraph number 7, as quoted herein above, it has been an admitted fact. It is an admission on the part of the Finance Department that the recommendation of the SETI Commission in respect to the stenographer grade 3 have been duly accepted. And on the basis thereof, the stenographer grade 3 were granted the pay scale of rupees 3,850, thus rupees 7,350. It is also an admitted fact from the very paragraph quoted above that rupees 3,850, thus 7,350, as per the ROP 1998, was revised to rupees 5,200, thus rupees 20,200 plus GP of rupees 2,900 as per ROP 2010. And subsequently, as per the rules of 2017, the revised scale is rupees 14,000 plus 70,000 plus GP of rupees 7,400. The question which arises in the instant proceedings is as to whether a person who have been appointed in the scale of pay of rupees 5,200, there's rupees 20,200 plus GP of 2,900. Would be paid the amount of rupees 5,200 as his initial pay. with grade pay of rupees 2,900 or the person would be paid by applying the corresponding fitment table paid in terms with the fitment table pertaining to the pre-revised scale of pay of rupees 3,850 - 7,350. In the previous segments of this judgment, while referring to the submissions so made by the learned counsel appearing on behalf of the petitioner, this court have duly taken note of that the various pre-revised pay scale which is it is relevant at this stage to take note of Rule 4D of the rules of 2010, which define the term pay band to mean in relation to any post/grade specified in column 1 of the schedule means the pay band specified against the post in the column 3 thereof. Rule 4G defines the term revised pay structure in relation to any post specified in column 1 of the schedule to mean the pay band and the grade pay specified against that post unless a different revised pay band and grade pay is notified separately for the said post. First, the existing basic pay and the revised basic pay have also been defined in the rules of 2010. In terms with Rule 4A, the existing basic pay means the pay drawn in the prescribed existing scale of pay, including stagnation increment, but does not include any type of pay like special pay, etc. On the other hand, Rule 4H defines the revised basic pay in the revised pay structure to mean the pay drawn in the prescribed pay band plus the applicable grade pay and ad hoc fitment benefit, if any, but does not include any other pay. Full stop. In the backdrop of the above, it would be seen at serial number 4 to 13 of Appendix 4 to the ROP 2010, that there are various pre-revised pay scale ranging from rupees 2,600 to 4,840 to rupees 3,500, 3,580 to 8,750, which were brought within the revised pay scale of rupees 5,200 to rupees 20,200. However, with separate grade pay. It is also seen that for the pre-revised scale of pay of rupees 3,850 to rupees 7,350, the grade pay was rupees the revised pay was rupees 5,200 - 20,200 with grade pay of rupees 2,400. As would be seen from the notification issued on 19th of February 2011, the said grade pay of rupees 2,400 have been increased to rupees 2,900. The rules of 2010 nowhere stipulates that the fitment tables In this regard, now the rules of 2010 rules of 2010 Rule 8 of 2010 of ROP 2010 stipulates the fixation of initial pay in revised pay structure. Subrule capital A of Rule 8 stipulates that the initial pay of a government employee who is in service as on 31st of December 2005 and is entitled under the rules of ROP 2010 to draw pay in the revised pay structure shall, unless the governor of Assam by special order direct otherwise in any special case, be fixed on the date he becomes so entitled in respect of the post or posts referred to in subrule B. Post. Capital B. Clause small a stipulates of Rule 8A stipulates that in cases of all government employees, the pay in the pay band will be determined by multiplying the existing basic pay as on 1/1/2006 by a factor of 1.86 and rounding off the resultant figure to the next multiple of 10. It is further stipulated that the minimum of the pay band is higher. Further stipulated that if the minimum of the pay band is higher than the amount so arrived at in accordance with after multiplying the existing basic pay by the factor of 1.86, the pay shall be fixed at the minimum of the higher pay band. Subclause 3 of Rule 8A is very relevant, taking into account the reference being made to the fitment table by the learned counsel appearing on behalf of the petitioner. And as such, the same is reproduced hereunder. From the above quoted clause, it would be seen that wherever bunching is occurring due to the initial stages for some of the pre-revised scales due to the fact that employees at this stage will have their salaries fixed at the minimum of the pay band as per clause Roman 2 above, an ad hoc fitment table benefit at the rate of 50% of the first increment, bracket rounded off to the nearest rupees 10, in the particular pre-revised scale shall be given for subsequent stages till the bunching of the pay is removed. the reference made of the fitment benefit in Rule 8, capital A, Roman 3 is shown in Appendix 7, which is the fitment tables. It would be further seen that from the fitment tables, more particularly fitment table number 4 to 13, that the basic pay in the pre-revised scale have been duly mentioned, ranging from rupees 2,610 to rupees 3,580. To rupees 3,850. To rupees 3,940. First, a person who is there in the pre-revised scale of pay at rupees 2,610 or 2,650, his revised pay in the running pay band is rupees 5,200. On the other hand, a person who is in the pre-revised basic pay of rupees 3,850, his revised pay in the running pay band is rupees 7,170. From the materials on record, there is no denial to the fact that being in the stenographer grade 3, the pre-revised scale of pay as per ROP 1998 is rupees 3,850 to 7,350. And considering that rupees, the initial, and considering that the first pay, initial pay in the said bracket, in the said pay scale, pre-revised pay scale, is rupees 3,850, which is at serial number 1. The corresponding revised pay has to be rupees 7,170. This court further takes note of that as the petitioner hearing, and at this stage, this court finds it relevant to take note of the objections so made, the submission so made by Mr. Arbor Puzati to the effect that the petitioner have not challenged his advertisement, the advertisement as well as his letter of appointment, wherein the petitioner has been put at the payment of rupees 5,200 to 20,200 with grade pay of rupees 2,900. In the opinion of this court, the question of challenging the said advertisement or the appointment letter of the petitioner does not arise, taking into account that the corresponding revised pay of rupees 5,200 to 20,200 with grade pay of rupees 2,900 is in relation to the pre-revised pay of rupees 3,850 7350. Accordingly, this court, therefore, is the opinion, and in that view of the matter, the instant writ petition, in view of the above analysis and determination, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, the petitioner's initial pay as per upon his appointment on 22/9/2016 has to be fixed at rupees 7,170 plus rupees 2,900 is equals to kiman hoye to didi. You won't get an increment on that date.
As per Shetty Commission, Lordship, 3% increment.
How can you get it on 29? You were appointed on 22. You can't get an increment till 1st of July. You cannot get that. Every time it happens after July, you can't get that increment.
But then that recommendation was there from Shetty Commission. That was
Understood. SETI Commission's recommendation, can you get it on the date of your appointment?
The date of appointment, maybe not, Lordship.
Absolutely. You will get it after, as per July only. You see, rule 11.
Yes, maybe not, Lordship.
You can't get it on that day. In case of promotion from one post to the higher post or the after the on the first of year, the fixation of pay. One increment here it says. It says whether refixation shall be done in so and so on 1st of July and those appointed after 2nd of July to and if he was promoted between here and the next 1st of July. So you can't get it on 2016. It has to be in 2017. Yeah, full stop. On the basis of the said, full stop. On the basis of the said, the respondent authorities, that is the respondent numbers, two, 3, 4, and 5 are directed to take 2, 3, and 4 are directed to do the needful for fixing the pre-revised pay scale, the revised pay scale as per the ROP 2017. Taking into account that the ROP 2000 rules of 2017 were made operational with effect from 1/1/2016.
1/4/2000.
1/4/2016. Full stop. Next, B. The respondents hearing, on the basis of the said, on the basis of the above observations made at clause number 1, Roman 1, shall thereupon compute the petitioners as to whether the petitioner is entitled for further amounts or there is any recovery required to be made from the petitioner. Full stop. Anything else? Number 3. Till such computations are not carried out, there shall be no further recovery from the salary of the petitioner.
It may be intimated, whatever the outcome is, Lordship, that may be intimated to her within.
The said exercise be completed within 3 months from the date of the instant order.
And it may be intimated to the. It may be
Will
intimated.
be done within 2 months. After submission of a certified copy of the judgment to the respondent number 2.
No,
Gusto.
we are not, I am not the employer. It will be, my lord, to
To the
the,
respondent number 3.
my lord, the
3.
second session, Lordship.
The,
No, my lord, the
Arveta Dio, the respondent number, who is the treasury officer, is 5, na?
5.
The treasury officers shall thereupon act in terms with the said directions.
Yes, my lord, it will be R4, the second session, the
R4, no, R3 and 4.
3 and 4, yes, 3 and 4.
At
No,
last,
but-
9.
I'm
confusion
sorry.
has ended.
I really, my lord. I am obliged.
Yes, what is this?
This is my lord, regarding my lord, completing of the legal year. As per,
Oh, this one.
yes, my
Have you filed anything?
My lord, I have received the copy yesterday. I've received the copy of their affidavit yesterday.
Somebody has died.
Yes, the petitioner who actually the original petitioner. Uh, she has expired and the affidavit has been sworn by her eldest son.
Okay. Who are the legal representatives?
son, man.
Huh?
Son.
There's nobody else.
Because there is a landlord tenant, my lord.
I'm
So-
not asking. You are the landlord.
No, I'm the tenant, man.
So
Tenant.
you are Bhanu Pratap Nath.
I'm the tenant, yes, man.
You are Bhanu Pratap Nath.
Yes.
So I make him the petitioner. It has been brought to the attention of this court by Mr. S. Nath, the learned counsel appearing on behalf of the petitioner, learned counsel in excess, it has been it has been brought to the attention of this court by way of an affidavit filed by one Bhanu Pratap Nath. He is the elder son of the revision petitioner who had preferred the revision petition. It has been also mentioned that the revision petitioner had expired on 24/2025 at Silchar, and to that effect, a death certificate has been included. Taking into account the above, this court substitutes the petitioner herein who is the legal representatives of the revision petitioner, the applicant substitutes the deponent of the affidavit dated filed on 13/5/2025, who is the legal representatives of the revision petitioner who expired by as well. Accordingly, respondent petitioner herein is substituted by Sri Bhanu Pratap Nath, son of late Horendra Kumar Nath, resident of Radharaman Saroni, Atkola, Silchar Town, PO and PS, Silchar, in the district of Kachar, Assam, pin 788001, as the petitioner number 1.1. The council appearing on behalf of the petitioner, Mr. Asnath, though submitted that the said Bhanu Pratap Nath is the elder son, but taking into account that in a landlord-tenant matter, the it is tenants in common, na? The rights of the legal representatives being in tenants in common. The said Bhanu Pratap Nath can alone pursue the instant proceedings without there being any necessity of substituting any other legal heirs of the deceased revision petitioner. First. Records is there?
Record, sir.
Come, chalo, dispose of. No?
Come upon admission next to me. Today I am not. Admission column, come up next.
List the matter again on the council appearing on behalf of the petitioner, Mr. Asnath, is directed to file a fresh memo of parties
Yes, sir.
within 3 days from today, by Monday, by 19th of May 2025. Full stop. On the basis thereof, the registry shall make necessary correction of the records and also update the same necessary correction of the cause title as well as also update in the CIS. Full stop. List this matter again for on 10th of June 2020, 11th of June 2025 for admission.
Admission.
Full stop. Interim order pastoral issue continue till then.
Item 18.
Yes, tell me. Yes, others may go. This matter will take some time.
This is the regulation, frame as per section 68, section 68C.
Tell me one thing.
Lordship.
A juvenile justice act college. Tell me one thing. The adoption can be done under the Hindu Adoption and Maintenance Act.
Can be done.
Mother wants to give it
Lordship.
because the mother is the only there. There's no father.
No father.
Then what are the formalities then?
The entire procedure which we have placed, these are under the juvenile justice system.
Juvenile justice on calculation not Juvenile justice act will come into when adoption is done under what provision?
The adoption, kindly see, section
Under 62.
58, 58,
68. Let us see.
58. 58.
58.
Right.
Adoption by Indian prospective adopted living here.
It
Indian
starts at
prospective
56.
living in here, irrespective of the religion, if interested to adopt an orphan or abandoned or surrendered child, may
56.
apply for the same in the specialized adoptions agency in the manner as provided in the adoption regulation. So if it is given under this provision,
Lordship.
now if it is the case where the mother wants to give, what is the procedure? Yes, Mr. Sahu. Hindu Adoption and Maintenance Act. Then what is required to be given? If I am not wrong, what is required is there has to go to the court.
Registration. Registration.
How? Registration under what provision? The court has to give. This adoption, you need to file application, file the AR to the effect that the court has to be satisfied. Let us see the Hindu adoption. Huh? No, there is some requirement. The adoption has to be there. Hey, Hindu adoption and maintenance. You are respond number 7?
No.
Who is respond number 7? You are there? You have no problem in giving the adoption? Let us not go into this Kara business. Kara will only come when it is a juvenile justice. Let us take away from them and do the adoption in proper manner. Hindu adoption and maintenance. Because if it is taking, you see, the basis idea behind this adoption is to be done at the fastest possible thing, taking into account the child's welfare. We are concerned out here on the basis that you see a child at a very tender age develops affection towards the, whoever it is, affection, whoever cares. The child, when he is born, he doesn't know who he is. He develops affection on the basis of his affiliation towards the person concerned. Now, in a case where the child who is just the way needs from infant to be from infant to baby, if he's at that stage taken away, things are very different then. Let us see how Hindu Adoption and Maintenance Act works. Huh? Minority and guardianship. Hindu Adoption 56 Act. Let us see this adoption. Person capable, capacity, Hindu, female. What is the formula to be given? Persons who may be adopted. He is a Hindu. Other conditions for adoption. Adopted son, neither any deed of gift or acceptance executed or registered or non-acknowledging is sufficient by itself to constitute a legal adoption in the absence of how an adoption is carried out.
Requisite is section 6, requisites for valid adoption.
No, that is under the Kara. This is
No,
under juvenile.
No, here section 6. Section 6 of the Hindu Adoption Act.
Section 6.
6.
11.
Requisites. No
Requisite-
adoption shall be valid unless the person adopting has the capacity and also the right to take adoption. The person giving in adoption has the capacity to do so. The person adopted is capable of being taken in adoption. The adoption is made in compliance with the other conditions mentioned in the chapter.
Yes.
So what are the requirements?
11, section
11.
Section 11.
Other conditions.
And the proviso parties, they have provided the performance of Datta Homan shall not be essential to the validity of an adoption.
The difference between Hindu adoption and this, juvenile anybody can take, irrespective of the religion. But Hindu adoption, it has to be only by Hindu. All have to be Hindu.
Here the parents know the child is going to whom. On the Hindu adoption, they know. On the Hindu adoption, the child of the biological parents know that we are giving adoption to this family. In Kara, the parents doesn't know the child will go to whom. Because it is the authority in the portal, it will be there. From the portal, authority will give the intending parents will give some option, and out of that option, one child will be given to them. Whether it is a boy, whether it is a girl, they are not concerned with that. The expected and others, ultimately it is the authority, they will choose, the parents and the child, they will.
And when will it fall within the ambit of the Juvenile Justice Act?
Well, here juvenile justice comes in because the annexure is there after 1 month of his birth by a deed. It was not notarized. By a deed, they claim that they have taken the boy, they have adopted the boy. When the information comes to the Child Welfare Committee, Because the Child Welfare Committee, the section 80 says, 80 of the Juvenile Justice Act says, if some adoption has taken place and that is not as per the regulation, that is illegal, and action has to be taken against those persons or the institution, and that is a punishable offense, 1 year imprisonment is there. So ultimately, when the information come to the Child Welfare Committee, they have investigated and ultimately an FIR has been lodged. So when the FIR was lodged, the explanation given by the parents, the present petitioner, is that we have taken the boy, we have adopted the boy, and this is the deed. So what the authority found that that deed is not a valid deed. So they have not ultimately complied with the regulation, the provision which is given under this act. That is how
No, therefore I'm saying, if a deed is made in terms with the Hindu Adoption and Maintenance Act 1956, is it invalid?
No.
Then why did it find that it was invalid?
Well,
It may be invalid in terms with this one, juvenile justice.
the act can be, if the deed is taken,
Where is that?
that they have annexed in the writ petition. Page number 15. Annexure number 2, annexure 2, page number 15.
Then this is to be registered.
Actually, not compulsory registered.
Hmm?
There is a provision in the Registration Act. That also speaks about the right to adoption, not regarding adoption. If you lordship with the registration.
Registration Act.
Act.
No, registration Act. No, here, what are the prerequisites of a valid adoption? First, they have to be Hindu. Secondly, the age has to be different by 21 years. Isn't it? 21 years. Thirdly, if they have a child, male child or a female child, they cannot have a female child. They can take a male child by theory, but they say that they don't have any. Number 4 is they have to have the means. They have to have the means that, okay, I will provide good care to the child. They have to have the means. So these are the requirements. Now, isn't it required that this neither any deed of gift or acceptance executed and registered, nor deed of acknowledgement acknowledging itself by itself to constitute the adoption in presence of an actual giving or yeah? It is not a substitute for actual giving or taking. Omissions of day or date of a year in the deed of acknowledgement is very vital. Such a deed loses all significance. Subsequent marriage of the adoptive mother cannot invalidate the effect. No, the only thing I'm worried of here is this. There is certain requirement of checks and balances also, which the provisions of some of the act or regulations do. That is like Kara and all these things. But if there is an adoption, if this act is, if, does it say that, because here the difference of 58 or the adoption shall be resorted to for ensuring right to family for the orphan, abandoned, surrendered children as per the provisions of the rules made thereunder and the adoption realm. Now, nothing in this act shall apply to the adoption of child under any of the provisions of ER. Now, kindly see 56.3. So this act shall not apply if an adoption is done under the Hindu Adoption and Maintenance Act.
Yes, that is there. But it will not.
But what is the checks? There has to be certain checks. Is it required that the registered deed be registered? Let us see the registration act.
This one, right?
17.
17. No, no, it's not mine.
Authorities to adopt a son. A son. What does it mean? Authorities to adopt a son executed after 1st day of January 1872, which means 1872 is the contract act, and not conferred by a will shall also be registered. Authorities to adopt.
In my understanding, my lord, if somebody authorize somebody else to adopt in his behalf, in that case, that authorization is to be registered, compulsorily registered.
Why the state says that this is not in accordance with the law? Maybe not in, because if it is done under the Hindu Adoption and Maintenance Act, this is out.
It is out.
These regulatory bodies is also out.
Then,
But
then
at the end of the day, however, the social welfare has a power to look into the well-being of the child.
But then, my lord, when the information came on 12/1, kindly come to NHF 5 and FI was lost. The Child Welfare Committee lost an FI before the Khetri police. Just to understand what the facts are, they have annexed Khetri police first information contents. Khetri PSS number 4 of 2024 under
Page?
section page
FIR.
number page 23 NHF 5. Khetri PSS
Recommended
number
to investigate and without any-
4/2024 under section 80 and 81 of the Juvenile Justice Act. Complainant Jitu Datta is the chairperson, lodged an FIR stating that on 27/5/23, while the accused person, namely so-and-so, the petitioner, the accused persons were illegally adopted a minor child and accused Nanda Pal made a false adoption deed. Hence this case.
Why do they say that which prevailing law does not permit?
Uh,
In the FIR?
They say that because the adoption regulation is there, that is what they have referred.
No,
because
but the adoption regulation is made under the juvenile justice.
juvenile justice. And the
So if juvenile justice categorically says it does not affect the rights under the Hindu Adoption and Maintenance Act, because you see 56.3
I
says,
have
nothing in this act shall apply to the adoption of a child made under the provisions of the Hindu Adoption and Maintenance Act.
56 cases.
Further, it is mentioned that the letter and advocate Sri Nanda Paul also stated by adoptive parents made the false adoption adopted. observe that already means so was aware of what this is. It is wrong. Has this been quashed or not?
No,
Not quashed.
not one. Page number 25 is the report of the police to the Edison Season because
Page
even-
number?
page number 25. This is the report of police, what they found after the investigation. In the letter, it was alleged that the CWC Kamrup Metro, from the very beginning, doubts the sincerity of the family of the victim child, and tendency of stealing the child has been noticed. The child is
Right, the mother has duly admitted that a child has been given on adoption.
she is a POXO victim, and the child is a rape, out of rape. The mother of biological mother, she is a POXO victim, and out of that rape, the crime, the child was born.
Honestly, there's no
Therefore,
quarrel with that.
therefore,
But if they
therefore,
want to take in good care for the child, that is the question we want to.
true. And therefore, it was given. And finally, my lord, the Child Welfare Board, when they found that adoption has been done by, they claim that adoption was done. Therefore, in the board, they discussed and then they recommended that it is to be investigated, and they said that it is not a adoption as per the regulation. That is what, because they doesn't know, my lord, they have no power under the Hindu law. They are serving, they are functioning, they are the authority under the Juvenile Justice Act. And they are privy to the adoption regulation.
This is a habeas corpus petition
They filed the habeas corpus petition.
for production of the child.
Yes.
No, upon everything is being done. Mr. Sahu, what is it? Another deed of adoption is
Yes, on 12/1/24, when the complaint was filed, on the same day this was done. Madam.
Huh?
This is dated 12/1/2024, page number 31. When the complaint was filed by the
Now
CWC,
there is another one at the page 15.
page 15 is the first one. So they are not consistent.
And 15 and here, what is the difference?
This is notarized though.
So they have just, otherwise it's same. Contents is same.
Some more contents are there, and it is not right. Earlier one was not right.
Mr. What is this petition under 438?
They filed a bail application because the FIR was there against them.
Bail got,
They
you got the bail.
Yes, they got bail.
Very good. Mr. Sahu, you find out what is required to be done. I think the best option is if they have the deed. You see, one thing why I'm worried about is there has to be certain checks. There's no that, oh, somebody takes away the adoption. Now, there is a proof to be made in respect to these deeds. Like the mother is willing and these people are willing to take the child. Making a deed in a proper format, doing everything, and placing it before a jurisdictional magistrate, certaining and then passing an order. Because I saw somewhere that an adoption can be done. Can there be a proceedings for adoption? No. Only worry, what is the worrying thing is this, otherwise there is no problem. This court will very well direct them. But that is not the question. The main worry out here is, we are in a case where 1956, the act was made. It's almost 100 years old. 75 years old. things have changed a lot. No doubt, the Juvenile Justice Act excludes the Adoption Act. But there is also a case of a misuse can also happen. How do you prove that there was a valid adoption? Valid adoption can happen on various aspects. The recognition, if there is nothing in the act, if you see that some of the judgments also, valid adoption can happen when there is a recognition by the society also. I remember while I was doing one matter as a lawyer, there was a case pertaining to a girl being adopted. She was brought in and adopted by a Garo family. Now the question is, you see there is a difference out there. When it's a case of a Koschari, the inheritance is made by the son, as per the customary law. If it is a Garo, then the daughter gets it. So that was the case. So there was the case that there was no valid adoption. While reading out there are many aspects where it says how there will be a valid adoption in the Garo customs. They have a customs by how it is done. So there are certain judgments also to the point as to how there can be a valid adoption. Means what the court will recognize to be a valid adoption. Normally there is no problem. You need to, therefore you see the judgment which have been referred here. Is what judgment has been referred here. Effect of adoption. Neither any deed of gift and acceptance executed and registered, nor the deed of acknowledgement acknowledging adoption is sufficient by itself to constitute a legal adoption in absence of actual giving or taking. Meaning thereby there has to be an actual giving and taking. You will prove. Now, if it is an actual giving and taking, court of a magistrate can duly recognize that aspect.
What parents
To take away a child, Mr. Nath, the problem arises is having a deed, rightly or wrongly, there is a deed where a mother is agreeing to take away the child. What authority you have?
Under section, under section 80 of the Juvenile Justice Act, whenever an information comes to the authority that there is an adoption which is not as per the law,
Law means?
uh,
Law means what law?
which is, I'm just reading the section.
No, understood. That will only come in respect to juvenile
Under this act.
under this act.
Yes, absolutely.
But if it is done under this act, how can you say that? That is why I'm concerned. Yes, if there is an ill treatment to the child, the social welfare department comes, they will obviously take it. Because the question is therefore, which Mr. Sahul on the last time said, to see the definition of a child, the child has to have the want, the need, there is a requirement for protection of the child. If the child does not require, how do you do it? Only question is that. Now, if rightly or wrongly, first of all, whether a deed of adoption is required or not, if they have performed, the society have said that yes, it is.
That's true, but here those are missing. Those are missing. Those facts are missing.
So therefore, the
In this case,
authority
those are missing.
authority could not have merely on the basis of the juvenile justice system. But the only worry which I have is that there needs to be also some certain checks.
Checks and
Where will
balances.
you have that check?
Check and balance has to be there. Otherwise,
Hmm.
otherwise nobody will come under these provisions. Because
No, somebody will come. Somebody will come means, just for example, there is a Hindu man, Hindu family who wants to take a child. Or some family members, they will like to take it. Or some, who does not come within the Hindu. But if you see the Indian Succession Act and all this thing, there's also the adoption. Adoption is not there. Illegal marriage is not there. That day I was taking up one matter of here. If there's a void marriage, interestingly, in Christian, if there's a void marriage, the child cannot come within the ambit of succession. Although in the Hindu Marriage Act, by 16 it is protected,
It counts.
but in Hindu, Christian it is not. So then what happens to the child? So then this needs to be tackled up by way of the juvenile justice system. This seems to be the only law out there. But if it is a Hindu, how do you have the checks to that effect? How much? Because otherwise there might be some operation, somebody may do whatever may be. You never know. Nowadays things are going this way or that way.
Going.
But your right only will arise if the child is in distress, isn't it?
Yes.
Otherwise you could not have taken it.
But that is one aspect. If the child is in need of care and protection, that is one aspect. Other aspect is section 80 says that if any person or organization offers or gives or receives any orphan, abandoned or surrendered child, any child, then for the purpose of adoption without following the provisions or procedures as provided in this act, such person or organization shall be punishable with imprisonment of either description for a term which may extend to 3 years, or with fine of 1 lakh rupees. So there are punitive measures for adoption without following prescribed procedure.
No. If any person or organization offers to give or receives any orphan, if any person or organization abandoned or surrendered child for the purpose of adoption without following the provisions or procedures as provided in this act, such person or organization shall be punishable and so and so. But if it is may not be in conformity with this act, but how do you take care of that? Because this does not overrule the Hindu Adoption and Maintenance Act.
No, Malado, the situation is like when they got the information, they at the first instance they doesn't know what has happened. It comes only after investigation, what the details. When the investigation came and they came to know that this particular family, they have no child, but they have taken a child from someone else without following the procedure, because the authority under the Juvenile Justice Act, they know that this is for them, this is the procedure. This procedure has not been followed by these parents. Therefore, they have a doubt, and under this 80, and they have informed the police that possibly they have illegally adopted someone. So this is the FIR. Then, the specialized agencies are there under the regulation. All these things are there. If orphan, if abandoned, if surrendered child, ultimately one thing Lordship may kindly consider: the mother doesn't want to have the child.
Huh?
The mother doesn't need the child. She has said that she doesn't need the child. Mother, the biological mother.
Oh, mother. Oh, mother.
Biological mother, she doesn't need the child. Ultimately, immediately after the child was born, the information came when she was 28 weeks pregnant. She is a victim, we are not on that. So ultimately, she doesn't need, and now the child has to be taken care of, and there are specialized agencies, they have to ultimately take the child to that particular agency, and not only this, abandoned or whatever child, orphan or whatever child, there is an agency under the provisions of the juvenile justice system. So they have taken the child there, and proper care and everything has been taken of the child. Now comes the adoption part, and therefore immediately they.
Who has taken the child? I mean, after it was born.
No.
After it was born, it was with them.
It was the child born in the month of April. After 1 month, they said in the month of March. After 1 month, this particular present petitioner, they said that we have adopted the child. And that is the date. Second date, they have also annexed, that is annexure 6. When the information come to the CWC in the month of January, then everything has happened, everything has started. And since the month of January, they have taken the child and keep it in the particular place,
January 2024.
24.
My
This case is going on for last 1 year.
We do one thing.
We'll see, my lord,
I'll take it up next Monday, Tuesday,
Lordship.
in camera. Ask the parents and that parent, the child mother to come. I'll have it in camera.
Lordship.
I think better. This is the in-camera proceedings. I'll take
Yes,
it
my lord,
at 1 o'clock.
1 o'clock. So in the meantime, I'll also take an instruction because this is the option, my lord. We are also talking, my lord. I call all the officers tomorrow, yesterday, my lord. on my
Mr.
office.
Nath, why I wanted, if it is done through you, it is more regulated. You understand that?
Absolutely, absolutely. True,
You see,
true.
once it is through Kara, what happens is, this act, only problem which I am facing out here is this act, where there is no checks and balances. Now you have the Kara. There is no case. Against them, there is no case. This court can very well direct, taking into account this is a valid adoption being done. Once I am satisfied to that effect. Now the question is, if it is done through you, only thing why are they are bound. They are regulated, it is channelized. This is the reason why I have been asking you that you kindly do it. Because of the fact that they are channelized. Otherwise, with this act, you can very well do it. You can't take over the child like this.
Well, I have called all the officers who are well, in the.
Tell them to get it done. Once it is being finalized and done properly, then it is okay. And it is a process. Give the child. They will take care of it. Tomorrow on Monday, Tuesday, we'll meet
Tuesday,
both of them.
Yes, Tuesday on.
Tell them, madam, also
I
meet
have
it.
to, I have to also, get two instructions, because if it is under Hindu Adoption Act, there is no difficulty, because I have seen that Hindu Adoption Act permits, and the 56.
Only thing why I wanted, if it is done through Kara, as they have applied, then they are bound. They are bound by certain rules and regulations. Now here they don't do it for Hindu law, they have not done it, but they will be bound by something that, okay, you can have this look and all these things, these people can very well look into it. These are the things. That is why I say it so.
What I am.
Even Tara has power to supervise.
Yes, ma'am.
After adoption, Tara has
That is
power
the
to
reason why I am concerned to that effect.
what
That
I am-
tomorrow the child, anything happens, they will be only already under constant pressure to look into the well-being of the child.
Yes,
I'm not, the main concern is that. That is why I have appointed Mr. Sahu also for that purpose. And he is taking he's a very, otherwise very expensive lawyer. So he's giving a lot of time to this.
Well, I have explained. I'm
It
thankful.
is
to-
also pertinent to
only-
mention, my lordship.
What I am trying to convey your lordship, Lord, because of the proceeding, this case is going on for last 1 year, and because of the proceeding, Lord, in the meantime, there is a process of surrendering the boy.
Huh?
The boy has been surrendered. There is under the Kara, these provisions, adoption regulation, there is a process for surrender of the boy. The biological mother has to surrender. This has been done in the month of January 2025. It was done, and there is a provision for declaration having a certificate that legally free for adoption. The now boy has been certified that he is legally free for adoption. These things has happened because the case is going on, and one by one, because they have applied, and steps by steps things are moving. So these two things are there. I have asked them, since the boy has been now surrendered and the legally free for adoption certificate you have given, if now they want to say that no, this is a Hindu adoption, and what if there has to be something has to be done or not, that instruction I will take on Tuesday. Lordship is taking up. I'll claim.
Mr. Nath, don't worry. That I will say has been done as per the orders passed by this court.
Malan.
And I will take care of that.
Yes,
aspect.
Malan. That is the
So that aspect I will take care of it. Don't
Malan.
worry with that.
Malan.
Only thing is, my only worry is this, because you see, I can pass an order out here to the effect that a child, but this I'm only worried that this may have a precedent. which I don't want. Therefore, I wanted that let it be done through Kara. If it can be done and done, people will do it. But you need to get the child out from there and give it to the, because if you don't, if you delay it further, this court cannot
But
wait.
from our side,
Yes.
from
Yes.
our side, Lordship may take it, my lord, that we are not, creating any problem.
No, Mr. Nath, you have to understand one thing. I'm only worried one thing. A child loses the affection, affinition. These are very important things. When they are born out there, what their love which they have with the mother, and once it becomes a longer period, then things becomes very difficult. There are a lot of people out there where they get the child at the birth so that they imbibed into the family.
Again, my lordship, it is
Absolutely,
pertinent to
absolutely.
mention.
Huh?
Again, my lordship, it is pertinent to mention that the petitioner have given, getting their birth certificate from the concerned authority. So before issuing the birth certificate, if arise some complaint, then they must be compelled to the follow the proceeding, my lordship.
Okay. List this matter again.
Because they are armed people. Huh? They are
20,
not
25, 2025 at 1 p.m. in the chamber, comma. The petitioners herein, as well as the respondent number 7, shall be present in person before the court, and the matter would be taken up in camera in presence of the counsels.
My lord, in respect of item number 20 in the supplementary list, it was fixed at 2 today. Lordship, may I pray for a date, my lord?
What is that matter about?
Regarding fixation of pay of a stenographer grade 3 of this court, my lord, High Court's employees matter, my lord.
Your stenographer grade 3 has created a havoc in the
Grade 2,
morning.
my lord, I'm sorry, grade 2, my lord.
Make it grade 2.
I'm
Today,
sorry.
the whole day I have gone with a
Yes, sir,
stenographer
grade 2,
grade
my
2.
lord.
Have it in next week. Next week. Mention it, we'll take it up at 2.
Like, it may be reflected in the cause list, my lord, at 2.
So and so listed on so and so at 2 p.m. The registry shall show reflected. লেখা না যায় নি? লেখা না যায় নাকি? To believe.
My lordship,
Well, it is already reflected at 2.
Next,
But today this matter went on, no?
Yes, yes.
Another stenographer grade 3.
my lordship, one thing, 20 May, my lordship, my one argument has in the Rongya court, my lordship, in that section of.
Who is going to argue?
376.
Who is going to argue?
I am the accused,
Not the petitioners?
no, not petitioner.
Ask the petitioners to be there. I don't want you. Mr. Sahu is there, na? Don't worry.
But my lordship.